Any matter today.
14th is the information I have to give in advance, but we
Mention tomorrow, please.
My lord, number 135, allow me to write 6, 7, 10, 18 candidates.
Today is not the mentioning date. Sorry. Please call the list.
Seventh is the exam, Lordship. Seventh is the exam.
Maybe.
I mentioned yesterday, Lordship, directed my mind to appear tomorrow, Lordship. Identical matter, Lordship.
Mention tomorrow. Mention tomorrow. Call the list.
Whatever your lordship must say order.
so stupid. What's the at least
Lordship, seventh is the exam.
Yes.
9th and 7th is.
What can be done?
Lordship, your letter, Lordship.
Why you are coming today? When the examination was declared?
yesterday. How do I come?
What?
The admit card. I was given admit card. Now withdraw.
That is my
Yes, because you are in the tainted list.
That's another. That's the lordship which to decide. But I could not have come up before. That's my point.
After the list that we found out that we are tainted.
You will take up with
Okay, as per the Lordship's order.
All are tainted will come now.
the
After the water has flown so much down the river Ganges. Please, I will know. I know. All 118, 2018 candidates will come now. Yes.
That we are not taking.
Yes.
As per the order passed by the Honorable Judiciary.
Yesterday.
They will file it, give the number, then I will consider.
Answer leave.
For your matter, your junior mentioned yesterday, this was prior to publication of list. So I have disallowed this mentioning, Mr. Ghosh. Sorry, all matters cannot be taken up in this fashion. File it. No, all matters cannot be taken up in this fashion. These are the matters where candidates are coming after publication of list. Your matter is appearing in the list. It is not possible. I have disallowed.
Otherwise, you want to obtain the final.
My matter is regarding untainted.
Untainted candidates, what happened? Your name is not in the list.
No. My name is not in the list. In this matter, what happened is that commerce has been divided into two subject categories. There is accountancy and commerce. But my clients are eligible to sit for both of such categories. Well, the representations were made, but that was.
But both categories are not being permitted under the rules. You have applied under one category. You have applied. Have you applied under one category?
I was.
Yes. So therefore, it is not permitted that both the categories to appear under the rules.
If I have.
And rule has been already upheld by this court right up to the Honorable Supreme Court, excepting one rider that to the extent of 50%, that has to be relaxed in connection with other
The
candidates.
petitioners are already agreed in respect of the earlier.
Sorry, file.
Item 142, my lord. It's a secondary SLST matter, my lord. The blind persons, my lord, before your lordship. My lord, you get the issue.
Matter was mentioned yesterday on blind matters.
Not it's filed by me. It's a blind person association and the members of the association.
I have association came. I have allowed on mentioning. Let this
My lord,
matter come
this
up.
this
Sorry,
matter.
yes.
This
One line leave is not given, we cannot file. It takes at least 48 hours to file. The matter will not appear tomorrow and we cannot serve notice on the state unless a leave.
Why you are coming today?
The list was published on 30th August, Your Lordship.
You are tainted candidate.
They have categorized us as.
Whether I am asking you whether your name is in the list of tainted
Yes,
category.
It is in the
Yes.
list. But why I don't know, because I do not fall in the category of tainted as has been decided by Your Lordship and the Honorable Division Bench, Your Lordship.
Give us the technical
We shall satisfy Your Lordship. We shall satisfy Your Lordship.
No, cannot case to case basis. Yes.
Definite petitioner appeared in denying base matter in HS matter. In all papers, he got more than 90%.
You are for the petitioner, not commission.
No.
The wait in that.
One line leave. One line leave that the leave is granted to a matter.
Because the case to case basis, not all matters.
There is inverted error in the list in the during the filling the form, and petitioner by mistake select the wrong subject.
Sorry.
This
Yes.
was not.
Sorry, not possible.
Admit card now withdrawn. Day before yesterday. I was given admit card. I was not.
Thursday.
My letter petitioner.
No, all matters cannot be taken up. Yes.
Chapter.
Tainted list. Petitioners are in the tainted list or not? Thursday, yes, yes, what same? Thursday,
This matter, my lord, is already appearing.
My
in-
lord, I want that also. Stated this, my lord.
I have disallowed mentioning, sorry, Mr. Ghosh, please call the yes, what is your matter?
Malad, here malad petitioner malad appeared in yeah, class 2 malad examination in NI.
बोले दी,
All
बोले दी.
malad more than 90% in every subject malad. Except in physics malad 0. Malad he appeared in the joint entrance examination and secure malad highest rank, high rank.
So it is under the list of Justice Basu.
No malad. For your lordship. Malad, the matter was moved before the honorable justice Moniludha Roy malad. And his lordship directed the matter to appear before the regular bench.
Yes, what is the urgency? Please tell me, I don't follow.
Joint entrance examination counseling is started, malad, already.
So that is joint, I do not have determination so far joint entrance examination is concerned.
Malad, I am challenging the mark sheet of NIUS, malad.
Very well, but it is under the higher education,
Malad, NIUS is under the
maybe, but you are praying for permission to participate in the counseling.
No, malad, I have challenged the decision of the NIUS in giving 0 in physics.
So NIUS is, what is NIUS?
National Open Schooling Institute.
Yes, yes.
National Institute of Open Schooling, malad. It is malad class 5 to class 2.
So what is the urgency that today or tomorrow matter is to be taken up?
Malad, because malad, if malad by this situation my sports card are not changed, malad, I have malad lost this year.
So you tell me that what is the last date of counseling?
Last date of second, malad registration
Last date of counseling, please don't waste court's time. Last date of counseling,
second.
2nd September. It is already over. Today is 2nd September. Mention on Monday, yes.
This matter is already appearing on your lordship list as item number 76, my lord. Kindly, my lord, let it be heard.
Yes, let it appear. I will try to reach this.
So, your lordship,
Yes. No
your lordship
upgradation.
already fixed the other blinds matter. You also kindly fix.
You wait, what order will come is in that matter, thereafter you mention. Yes. Don't mention, today is not the date for mentioning. Why you are mentioning today? Yes, please follow the list. Sorry. Yes. Punta, no.
My lord, each paragraph will say that I mentioned.
How, why so many matters?
Different repetitions, individual candidates. They are not.
No, only one matter you give, that will cover other matters.
Malad, 11 September.
Sorry.
11
Mention on Monday. এই দিয়ে দাও ওগুলো ওইগুলো
Kindly add. Kindly add. My life is at stake. Well, I cannot apply my any reply to my client.
please call the list.
My lord, then my lord, kindly release it.
Yes, tomorrow to be mentioned for release.
My lord, then.
Item number 1. Tomorrow to, no, sorry.
I appear for the statement.
Yes.
I am for the petitioner minute. Minute, this is assigned to your lordship minute. The genesis of this case is cancellation of my birth certificate without giving any opportunity of hearing. Minute, I have prepared a short list of dates for your lordship's convenience.
Today it is appearing under the heading petition. Who are the appearing advocates appearing for the respondents?
Minute, the
For the statement.
Please for the state for the for Mr. Alok Ghosh is appearing for the case. May I proceed with the matter, minute?
Yes, what is the matter about?
Well, matter pertains to cancellation of my birth certificate without giving any opportunity of hearing. Well, there was a criminal.
What is the urgency?
Urgency is, my lord, date is fixed on 4th of September for consideration of charge in the criminal proceeding pending against me, my lord. And difficulty is this.
It's not possible in this side of the, in this week matter to be taken.
If you kindly to take it next week, my lord.
Serve notice, let-
Well, I'll sub, I'll take it up in the next week, my lord, on 10th or something.
who is appearing for the municipal, Kolkata Municipal
All of
Corporation.
course. All of course.
Disciplinary proceeding has been initiated against you. Then
Question of disciplinary
then-
proceeding, my lord. The issue is, my lord, I have been implicated.
birth certificate has been issued.
Yes, I have been implicated in a proceeding under Foreigners Act, alleging that I am an Afghan national. There is a birth certificate issued by the KMC indicating that I am the Indian citizen and this date of registration is in the year 1986. Now, your lordship knows that as per the Citizenship Act, if the birth certificate is prior to August 1986, then it is itself sufficient proof of the citizenship. No further document is required for the citizenship. Now, sir, initially, after I have been released, when I was in custody, report was called for regarding the document. Based on the report, I have been released on bail. Immediately thereafter, the authority first cancelled my EPIC and other. I preferred a writ. In that writ, that was the cancellation was disallowed. Six, they have preferred an appeal. Appeal was also dismissed. Subsequently, what they did, they have cancelled my birth certificate. Now I have preferred this appeal. During the pendency of this revision writ petition, they have preferred a cancellation of my bail on the ground by birth certificate has been cancelled. The Honorable Division Bench, considering the materials, did not interfere. Now, if this cancellation of the birth certificate is not taken into consideration and if no opportunity of hearing is given to
Cancellation of birth certificate has been issued by the
KMC,
corporation.
KMC.
So that has not been interfered with by the division bench.
That has not been interfered in the cancellation proceeding. That has not been interfered with.
So then what remains?
My lord, this the different jurisdiction, my lord, altogether. Because of the cancellation,
Already the division bench in the criminal proceedings has passed an order.
my lord, passed an order. The
Division bench, why? It was in the criminal
it was
revision.
a cancellation. They have preferred a cancellation on the ground of the
Cancellation of?
cancellation of bail on the ground of cancellation of birth certificate. Now,
Why it was in the criminal side?
well, there is a criminal proceeding under Foreigners Act against me, where I was arrested. I was granted bail from the learned chief judge. They have prayed for cancellation of that particular bail granted by the learned chief judge. In that cancellation proceeding, they have taken a plea that the birth certificate based on which I have taken all.
Why matter was considered by the division bench?
Well, the cancellation of bail is when at
Before, at that point.
at that point of time it was before the division bench.
After amendment, it is.
After amendment, it has been-
So it was a cancellation of bail.
It was a cancellation. But I have
The bail was cancelled.
No. It has not been interfered, Millet. Kindly
Now the very basis is this cancellation of your birth certificate.
birth certificate, Millet.
That cancellation is under challenge.
Under
in-
challenge in this
issue. Matter has come up in the list under the heading to be mentioned. On being assigned by the Honorable Chief Justice on 18 July 2025. Yeah, for the state.
And for the street.
Uh, Today, petitioner and state respondents are represented by learned advocates. However, Kolkata Municipal Corporation, being respondent numbers 3, 4, and 5, 3 and 4, are not represented. Next paragraph. Learned advocate for the petitioner is directed to serve notice upon the learned advocate representing Kolkata Municipal Corporation, enclosing copy of this order by September 2025. List the matter under the heading list the matter under the heading assigned motion on 16 September 2025. Next.
Item number 2.
Coming my instance, my lord, this matter relates to my lord
filed as a overdraw.
Non-prosecution, it was
Non-prosecution,
mentioned.
well, with the liberty to file afresh.
No. Non-prosecution, not with legal. Sorry.
It is, my lord, it is relating to 3% additional increment.
Yes.
My lord, I have filed wrongly as overdraw matters in 2023. But now, my lord, if I move before you, I cannot have the both. So, my lord, I will better particularly want to come up, my lord.
Matter should go back to its original position in the list.
My lord, I withdrawn with the liberty to file afresh. That is why, my lord, I mentioned the matter. My lord, I
But you
cannot,
have mentioned this.
my lord, because that particular, those judgments are,
Straightway, if you want to withdraw it, then I can pass an order. Otherwise, no.
my lord, I cannot file a phrase because it is 2023 matter.
The matter was running in the supplementary list. Why you have
Matter is not running in
from the combined list?
No, it is not. It is not running in the combined list. My lord, if I want to file afresh with better particulars,
Issue.
3% additional increment case, my lord.
Come up in the list under the heading to be mentioned on being mentioned by the learned advocate representing the petitioner. Next paragraph. Learned advocate for the petitioner, you are for the state. Learned advocate for the petitioner submits that petitioner is willing to petitioner is not willing to proceed with the matter and leave is prayed for to file afresh with better particulars on self-same cause of action. Next paragraph, state respondents are represented by learned advocate. Next paragraph. Having considered the submission made on behalf of writ petition stands dismissed on the ground of non-prosecution with leave to file afresh on self-same cause of action with better particulars. Parties to act on the server copy. Next.
Item number 3.
3 to 7, kindly pass it.
4 to 7.
4 to 7.
Yes.
Page number 5. 3 to 7 to the 4 to 5.
এইটা দাও না,
Sorry, ওরা কেউ এটা করে
এটা দিচ্ছ কেন? এটা তো আগেরটা করছো তুমি। ফাঁসাবে আমাকে দেখি কেন ফাঁসাবে? এটা আগেরটা, I am giving this. এটা তো প্যাজিনেট করো না, এটা প্যাজিনেট করো, তার করার সময় নেই, কাছে চাইবেন। উল্টোপাল্টা জিনিস ভালো প্রেজেন্টেশন বলেছে,
এটা প্রেজেন্টেশন ঠিক আছে।
আমি করে নিয়েছি এখান থেকে। তিন
Yes, file your report. Let it be considered by the commission since it has been allowed.
It has been allowed. It has.
In terms of the previous order, a report dated 26th August 2025, prepared by the District Inspector of Schools AC Hooghly, being respondent number 4. 4 is filed today, enclosing medical report, and same is taken on record. Next paragraph. On perusal of the medical report furnished by the Superintendent Imambara District Hospital Hooghly, addressed to the concerned Chief Medical Officer of Health Hooghly, dated 17 June 2025. Relying upon on perusal of the memo dated 17 June 2025 of the Superintendent Imambara District Hospital Hooghly, with the concerned Chief Medical Officer, relying upon medical report of Medical Officer District Hospital Hooghly, dated 17 June 2025, it appears that medical expert recommended for transfer of the petitioner on medical ground or on health ground. On health ground. Stop. Next paragraph. Respondent number 4 is directed to forward transfer application along with medical report to the Chairman, West Bengal Central School Service Commission, being respondent number 3, by fortnight from the date of communication of this order. Stop. On receipt of transfer application and medical report, respondent number 3 shall decide the transfer application of the petitioner by 4 weeks thereafter in accordance with law, and decision to be communicated to the petitioner by 10 days thereafter. Next paragraph. It is made clear that suspension of portal shall not be a ground to reject transfer application of the petitioner. Stop. Writ petition stands disposed of. Urgent.
Great.
For the next matter.
Item number 4.
Item number 4 to 7.
Yes.
Well, this is that matter your lordship was pleased to grant leave yesterday. Well, huh? Yes, Shompa Ghosh is 4. Shompa Ghosh 4. But kindly takes up records of my lord 5. But I have
Kindly keeps all these matters in that. Kindly keeps all these Mr.
You are appearing for the commission?
Mr. Bandopadhyay.
Yes,
is there.
let him come. It's not possible to.
We have not even received copies.
Let me hear the matter. Yes.
Yes, sir.
Yes, place your case, Mr. Shah.
Now, my lord, your lordship is having. My lordship I delivered a detailed judgment. I'll be relying upon.
Time is too short. It's
No,
not.
this is the copy of the state. We have not
Let
even
us,
received.
let us go through.
No
that.
instruction.
Let us
Mr.
go through together.
Yesterday it has been, sir. My lord, kindly takes up volume 1 first.
Yes. This is item number 5. Yes.
WP 20861. Candidates, sir, class 9 and 10 candidates. Next is 11, 12 candidates.
given a
whose
copy.
OMR as of today has not been published.
Yes.
Now, kindly comes first to the affidavit of the
All are in the tainted list.
allegedly, my lord.
Yes.
That we are challenging. Kindly comes to page 25. This is the, my lord, report which was filed by the commission in the first round of litigation before the honorable division bench. Page 25.
Where is the tainted list?
The
List of tainted
alleged
candidates?
tainted list is in volume 2, 259 to 292. Volume 2 lordship when it takes up 259 to 229. Amar bit ka volume. They have included persons who were not supposed to be there. They have not included persons who are supposed to be. And 28 August, there is no order. These are the list in
So this
respect
list
of
was
9,
published
10,
on 30th August
yes,
2025.
9, 10 and 11.
Now, whether the petitioner was working in class 9, 10 or 11, 12?
9, 10.
9.
In 9, 10.
Now, in terms of the order of the Supreme Court, whether the petitioner was permitted to work till 31st of December?
No.
Till 31st of December, what steps you did take?
No, my lord, that order will not stand in the way. I'll try to substantiate because we had
I'm
earlier
asking you
approached.
whether you are permitted to work till 31st.
No.
So after you are not permitted to work till 31st December 2025, what step you did take?
No, my lord, 11, 12 candidates had moved from your lordship's order on the last occasion. The honorable division bench was pleased to direct that if the matter, my lord, if the cause of action arises, then they will be having a liberty to move, my lord. Kindly, my lord,
Matter?
they will be having a liberty to challenge the same.
When
If their candidatures are cancelled. But kindly, my lord, kindly comes to lordship is having an idea, my lord. My lord, lordship has dealt with. Kindly comes to page 25. I'll not be very, my lord, I'll be very fast. Kindly comes to page 25. This is the third affidavit which was given by the commission, volume 1. Volume 1. Third affidavit which was given by the commission, which indicated the names of the persons. So therefore, kindly comes to page 28. This is straightway kindly comes to page 28. The categories of rank jump who are also within the expiry panel were 183 numbers in 9-10 and 39 in 11-12. Lordship has seen that. Now, my lord, kindly comes to the affidavit of the CBI, the written sub, page 117. The 117. This is the list of candidates called for 8-phase counseling dated 3rd August 2020, way after the expiry of panel. These persons have not been included in the tentative list. That is the case that I'll make out. Although these were supposed to be included. Now, kindly comes to the written submission of the CBI before the Honorable Supreme Court, page 123.
But the Supreme Court is insisting of the matter.
No, it is not. I will.
Yes,
It
I have
is.
seen the
It is from. I have annexed. I have annexed. I'll show.
Insisting of the matter.
I will show
Now,
you
why
from your
at this
lordship's
stage-
order.
Why at this stage court will enter into this issue?
May not. But after seeing this, lordship may kindly see.
Come to page.
I have, my lord, I have seen the order. It
28
arose out of your lordship's order.
Come
where
to
his
page
lordship-
28 August
28
2025.
20.
16 Bijoy Vishwas.
Yes, yes. My lord, three things there. I understand
Please
what
come,
is.
please come.
Yes, yes. 252 page.
Learned senior counsel appearing as commission that a list of tainted candidates who were selected, whose selection has been set aside by the High Court and confirmed by this court, would be placed
Placed in public domain, that is on the website of
the
such and
West
such
Bengal
within
Central
7 days.
Business
We
Commission
take this
itself.
statement on record. So it's a concession.
Yes, please come to the nenext order.
Next order.
Next
my lord?
order dated
Yes.
dated 29th of August. Yes, please come.
ঠিক আছে।
Internal page 4, second paragraph. That is in the case of Bijoy Padia,
বিজয় পাড়িয়া।
Vivek Padia.
কত নম্বর পাতা? বিজয় পাড়িয়া। বের কর না, আমার কালকে লাগানো, আমার বিটটা, Page 4. As we have already directed that the list of tainted candidates should
Directed list of tainted
which
candidates
order?
should be
Which
placed.
order? Kindly cease.
Should be placed in the public
Which order?
domain
Directed
within the period.
by
Directed
28th.
list of tainted candidates should be placed in the public domain within a period of 7 days.
Yes. I am not drawing any.
And
I am
that
not
issue is
saying
still
anything.
pending,
I am not
pending
saying
before
I
the
am not
Honorable
saying
Supreme Court.
my
At this
content.
stage, just before commencement of the selection process,
Yes.
court will not enter into a
Yes,
court
yes,
will not
Lordship may
conduct
not.
roving inquiry.
Lordship, it is not a roving inquiry.
Yes, yes.
It is not a roving inquiry. Kindly, I'll not. Kindly comes to your lordship's order, madam. Kindly comes to the Supreme Court order once, and thereafter your lordship's I'll show.
Yes.
Page 136. I'll be very short. Lordship is having an idea. Kindly page come 136. Kindly comes to the directions which have been quoted in the Supreme Court. Thereafter again quoted in the division bench. 136. Lordship is there in 136 of volume 1.
Yes.
Yes, it is being quoted, my lord, the order of the division bench which has been quoted in the Supreme Court. Kindly comes to 4. Persons who had been appointed outside the panel. Lordship is there. 1, 2, 3, and 3 has not yet been complied with because the 11, 12 candidates, they don't have their OMRs as of today in public domain. They know what were the OMRs recovered. Now kindly see 4. Persons who have been appointed outside the panel after expiry of the panel, and also those who submitted blank OMR sheets but obtained appointment must return all their remuneration and benefits received by them to the state exchequer along with the interest of 12%. So therefore, subsequently, the division bench has interpreted these persons to be the tainted persons. We are not outside the panel. I have
Just.
we have not submitted blank OMR. OMRs that annexed with the writ petition I can substantiate, and we are obviously not expiry of panel. Because we have been appointed in September 2018, January 2019. Now, Lordship has
Just a minute.
volume.
Just a minute.
এখানে যা এইটা দেখাচ্ছি, এইটা দেখাচ্ছি। নেক্সট আপ নেক্সট ভলিউমে আছে 150 করে দিয়েছে না, পরে পরে ভলিউমটা দেখ 159। হ্যাঁ, তুই সেকেন্ড ওয়াচ কর। আচ্ছা আচ্ছা, এইটা সেকেন্ড। But Lordship,
Just a minute.
I have annexed. I can, my lord, straight away indicate. Lordship wants your Lordship's order.
No,
The order passed by the division bench.
just
It is annexed. Oh, that copy, yes, yes. Thereafter, I'll be relying on paragraph 30.
just
I could have, my lord, assisted your Lordship, my lord,
I
indicate.
require your assistance.
Because I understand Lordship has read from another brief. Markings are there. I also feel this difficulty. Same thing when I read again.
This is paragraph 363 of the judgment
Of the judgment of the Honorable Justice Devanshu Bosha, division bench. Your Lordship requires the judgment of Justice Devanshu Bosha, division bench. Here the judgment is there. Or if your Lordship is having a marked copy, then Lordship may kindly take it from there.
It is 22nd April 2024. Judge.
Yes, yes. Lordship is seeing
Okay,
division.
paragraph 360.
Yes. That has been quoted here only because the judgment was very bulky. I have not annexed. I
Yes,
have read.
yes.
বলতে পারো। That's it.
কলম্বোকে বলি নাম অপোজ করেছি তার জন্য পাস হওয়ার ঠিক আছে। থ্যাংক ইউ ফর বাফার থাকা ভালো। কিশোরদা যখন সবে একটু সিনিয়র হলো, আমরা যখন ঢুকছি আমরা
You are relying upon paragraph 4 of subparagraph 4 of page 363
paragraph
of the
360.
judgment dated 22nd April 2024.
Yes, which has
Now
been
it says
held and thereafter
persons who have been
interpreted.
appointed outside the panel.
We are not
After expiry of the panel.
We are
and
not
also who submitted
blank
OMRs
OMRs.
but obtained appointments must return all
Yes.
remunerations and
Yes.
benefits received by them
Yes,
to the state exchequer.
yes.
But these are the probable, it's not possible to point out and pinpoint all the illegalities.
It has been
These
pointed
are the
out.
probable illegalities based on which honorable division bench gave directions.
Now division
Now,
bench
and
is
that is-
subsequently clarified.
And that is confined that what is the effect of these three contingencies.
Hmm.
The effect of 3 contingencies is must return all remunerations
Yes.
and benefits received by them.
Yes.
But
Now-
there may be other tainted candidates.
That is
Mr.
why entire
Nilai.
panel goes.
There may be other tainted candidates.
Illegally.
So therefore, at this stage, by roving inquiry, it is
Lordship
not
may not
possible.
do a roving inquiry. That is what I'm trying
Yes.
to say. Now kindly comes to page 159, paragraph 30 of Supreme Court. Lordship is having the Supreme Court judgment, my lord. Paragraph 30 kindly comes. Internal page 32. 30 and 31.
Of 3rd April.
Yes, Supreme Court.
এই আমাকে একটা সাদা কাগজ দাও।
It is easier. That is why, my lord, I am referring to the paragraphs. Roving inquiry will not be required. That is what I am trying to substantiate. Because it has already been interpreted and it has crystallized.
Yes, which paragraph of
Paragraph
judgment dated 3rd
30,
April you are
31.
relying upon?
Paragraph 30, 31. This is to substantiate that persons who were supposed to be included has been excluded. 30, 31. আমি কিন্তু oppose করিনি possible.
No, no, no.
Paragraph 30 and 31. 31 kindly come straight away to 31. WBSSC had tried to justify the extension of the term of panel. As noted above, the time period of 1 year specified in Rule 21 of the destruction of the OMR sheets coincides with the time period specified for validity of panel. There is no doubt that counseling process and the appointments made to the post of assistant teachers 9, 10, 11, 12 were made after the expiry of panel. This is illegal and contrary to the rules. Reliance on orders stroke judgments of the High Court in stray cases of rank jumping were highlighted, where the High Court directed to appoint candidates after expiry of validity of panel would not have been significant impact. The court at that stage was not concerned and aware of the illegalities in the appointment produced and not specifically examples. So therefore, court specifically says that expiry of panel illegal. But my lord, they have included
Just a minute.
Second one.
Yes.
Page 160. Now kindly comes to the ordering part of the Honorable Supreme Court. Lordship has read many times. I will not trouble your Lordship. Only page paragraph 45. Paragraph 45. The last question. Paragraph 45.
Yes, paragraph 41.
Lordship has, so therefore that order is not interfered. I may have shown your Lordship to I thought that I'll be drawing your Lordship's kind attention to your Lordship's order. Page 209 is your Lordship's order, your Lordship's interpretation. And paragraphs 21, 22, 23, paragraphs 209. It is your Lordship's interpretation. My lord, if your Lordship wants, my lord, I can place it. If your Lordship is of the view that I remember everything, I'll not. 21, page 209
Of your writ petition.
of the writ petition, volume 1. Volume 2, so sorry, volume. Hey, Sugoto that.
Page.
Page 209. Paragraph 21. On bare perusal of the concluding part of the judgment dated 3rd April.
Just a minute. Yes, explicit.
On bare perusal of the concluding part of the judgment dated 3rd April, it is crystal clear that on the finding of egregious illegalities offending Article 14-16 of the Constitution, when the entire selection process is set aside and not resulting in cancellation of the engagement of the two categories of candidates, one category was termed as tainted and the other untainted. While dealing with the appointment of tainted candidates in paragraph 45, so tainted candidates, paragraph 45 means 363. Of the judgment dated 3rd April 2025, it was categorically observed by the Honorable Supreme Court that their appointment was result of fraud which amounts to cheating, based on which judgment of the Honorable Division Bench dated such and such was not interfered with so far as the tainted candidates are concerned. At the same time, while dealing with the cases of the untainted candidates, it is observed in paragraph 46 of the judgment dated such and such, the entire selection process was declared null and void due to irregularities with violation of such and such. Therefore, Honorable Supreme Court found it fit to cancel the appointment. Untainted candidates were not required to refund the salaries which they received after appointment, but such relief has not granted to the tainted candidates. Only common feature between the tainted and untainted which was found by the Honorable Supreme Court is the appointment of both categories of candidates were required to be declared null and void. Therefore, paragraph 45 and 46 of the judgment, there is no gray area in differentiating tainted and untainted candidates, and same stands fortified if one considers observation in paragraph 29 of the judgment. Thereafter, though argument has been advanced on behalf of such and such, the difference may be Honorable Supreme in tainted untainted is only to the extent of granting, non-granting benefit of age relaxation. I am not concerned with that. Paragraph 23. It appears to this court that there is substance in the submission made on the petitioners that by no stretch of imagination, on reading paragraph 45, 46, 49, judgment of them can be considered to be tainted or permitted to participate. I also do not have any issue with regard to this. Now kindly comes to the appeal course judgment. The appeal carried by the by this commission. It starts from paragraph 215, page 215. I will not trouble your lordship with the entire thing. I'll be only praying that your lordship.
250.
215.
250 or 215.
From 236, the finding starts.
Why you are not going to the Supreme Court?
Yes, kindly comes to this division bench.
In terms of the order of the Supreme Court, this
that
list
has been
published and
interpreted.
today court will interfere.
That has been interpreted. That is what I'm trying. Kindly comes to page 200.
And more interesting is this: after publication of list, who were permitted to undergo or who were permitted to work till 31st of December.
There was no publication of list. That is my contention.
You are not permitted.
No, we were not.
You are not permitted. So why you did not make demo at that point of time?
Because at that relevant point of.
And now at the fag end of the just before the initiation of selection process, when a list is published, you are trying to unsettle it.
This is for the first time the list has been published. It was not.
That is in terms of the Supreme Court, and Supreme Court is in session of the matter. Mr. Lahiri, there should be a limit of everything. And you are coming on behalf of tainted candidates, allow us today. And you are not permitted to work till 31st of December 2020.
I understand what is falling from your lordship, my lord.
Enough is enough.
So
what tainted is concerned, enough is enough.
But we are not tainted. It has been said by division bench. Kindly see the direction of the division bench.
Now you have become senior advocate. You have more cases to do.
No.
Rather than appearing on behalf of tainted.
This is which we have been facing from 2023. Matters were taken up. We were not parties when we.
And what Supreme Court has said.
Just a minute.
Just a
May I
minute.
finish this?
Just a minute.
Matlab,
Just a minute. What Supreme Court has said, please come to page.
I will
Come to this order dated 29th August 2025.
28 or 29. 29.
29th August 2025. In Vivek Padia's case. Both the writ petitions are pending for consideration.
But Vivek Padia and the other,
Both the SLPs are pending for
yes,
consideration.
other,
Yes.
these both these matters arise out of your
He
lordship's
further
judgment.
says that
which has
if any tainted candidate slips through the net
Yes.
and manages to appear for the test, the notice dated 25th August 2025 issued by the commission stating that the eligibility and ineligibility of the candidates would be examined in the post-examination stage
Yes.
would come to the aid of the commission.
That is what I'm
So
saying.
what? No.
I will not
What
be getting anything if
court
I
has said-
participate. Even
court has
after
said that
getting the
if-
appointment letter, my appointment letter can be cancelled.
If any tainted candidate slips through Supreme Court,
Yes.
but with regard to the candidates who have been identified as untainted candidates, there was no
I will show.
there was no observation.
I will-
But in case of tainted, there was a direction, but
Even if I am a tainted.
further filtration.
Yes. Even if I am a tainted, I will not be able to get the appointment. But I will not be able to give the examination. And my lord, persons who have slipped in 183 numbers of persons that I have drawn your lordship's kind attention, they have not been included. They are now going and sitting in the examination after being appointed post expiry of panel.
What is disturbing this court problem is this, that after you are not permitted to work
I
till
understand
31st December.
why you have not come.
2025,
Why you have not
you
come.
did
But
not
my lord,
raise any demur.
I understand. But my lord, after giving the application, admit cards were given to me. Kindly comes to my lord. Kindly, my lord, may I just finish, my lord? 239 and 236 is the finding. I will not trouble your lordship. Kindly comes to the relevant part, 239 of the judgment passed by the Honorable Division Bench, presided over by the Honorable Justice Shomen Sen, arising out of your lordship's order. 238. 238, the paragraph 363 is quoted. 233, lordship is there. Lordship may not read it. Kindly comes to paragraph 32. Lordship is seen in paragraph 31. Paragraph 363 is quoted in deciding all cases.
Paragraph
31. 280, 238. টা করুন। এটা হোক। 31, 363 is quoted. I am not placing. Kindly sees. Subparagraph 4 is also there. Lordship has gone through minutely. Now paragraph 32. Paragraph 236(4) has classified 3 categories
Paragraph
of
32.
candidates. Yes, 31 is the quoting, quote unquote. Paragraph 363 has classified 3 categories of candidates who can be described as tainted candidates.
Then paragraph 363(4) was considered.
Now,
Yes.
persons who have been tainted outside the panel, we are not. Persons tainted after expiry of the panel, who are working and who will be participating.
That the probable tainted.
My humble submission is it is not the probable, my lord. This interpretation has been made by the division bench, not challenged, binding upon them.
Can just 1 minute I will.
And persons who have submitted blank OMR.
OMR mismatch tainted.
I'll be joining.
Yes,
an
just-
issue. I'll be joining an
Because
issue.
OMR mismatch tainted. OMR, OMR has been
Blank OMR.
fraudulently has been done.
Blank OMR.
Just hard OMR blank is also tainted. In addition to that, this is also there. They
That
are
might be
tainted.
their term.
I mean, tainted is a broad term. Yes, because these are what court is saying that paragraph 363, or the main paragraph of judgment dated 22nd April 2024 of the division bench, where it is stated that there are 3 categories of tainted. That is the probable categories, not all categories.
My humble
Not all
submission.
categories.
My
It is
humble
not
submission. This is the
possible
interpreted by the division.
to pinpoint all the categories of
Division
tainted.
bench has
Finding
pinpointed.
that from the division bench, when the bench presided over by Justice Basa, and also the Supreme Court, the tainted candidate in one case, it has been given the
দেখিয়েছি।
chart has been given. OMR. These are on the basis of the CBI. Right?
Yes.
These are all tainted.
Second is beyond the panel which who have been taken.
Matlab,
Oh, yes,
I have,
rank jumping. I was forgotten one. Rank
No,
jumping was also.
I am not
taken.
rank jumping. I have shown the list of
Yes,
rank
sir,
jumping.
rank jumping was also tainted. Rank jumping was also tainted.
Persons who had been appointed outside the panel.
What
after
I am
expiry
saying,
of the panel.
in addition, these are the.
Matlab, outside
these
the
are-
panel includes rank jumping.
It cannot be.
That is the
It cannot be said. OMR mismatch is not tainted.
Now,
Blank OMR is not tainted. But OMR mismatch is.
Blank OMR is tainted.
Had also submitted blank OMR.
Yes,
Blank
we have
OMR
not
is
blank
was
OMR.
classified as tainted
But-
under paragraph 363(4).
Yes,
Not
not
blank
that
OMR.
is. But here, what you want to say that we are not.
Mr. Lahiri wants to say that there are only 3 categories of tainted candidates.
No.
Under paragraph 363(4). What are those categories? Candidates appointed beyond the panel, candidates appointed outside the panel, and candidates who
Expired.
submitted blank OMR.
But then in that case, OMR mismatch is not.
blank OMR and OMR mismatch
But
is
OMR,
totally different.
OMR mismatch
OMR
is not.
mismatch is a one marks also.
OMR
I'll show.
mismatch is the greatest tainted candidates. Everything has been fallen because of the OMR mismatch.
Now, my lord, I'll show
OMR
your
mismatch
lordship.
is the. And
But may I complete, my lord?
this
Our
particular
senior friend will
paragraph-
get.
yes, Mr. Light, this is not nothing to be talked much. We are also facing the courts also. Let me very clear. We are treating them as a tainted. We are treating them as a
But
tainted.
persons who are supposed to be treated as tainted is not being treated as
that
tainted.
you challenge that.
I have challenged
you
here,
let them
here
party.
and now,
You
here
let
and now.
them party and come back. Then we will see
In
to
the
that.
in
Without-
neither of the
Well, anyway,
litigations.
Now, my lord,
Lordship
yesterday
is-
also,
Lordship is-
my lord, yesterday, although I was not there, I have received the instructions from my advocate on record. Yesterday also, one of the matter was taken up, and other petitions have been dismissed. One there we have said, they have shown. It will be very clear to your lordship if I say that there are mismatching of the list of the tainted and a CBI list, which we have said the list which has been published by the SSC, that they were all appointed, right? And the difference between that, they are also tainted. We are also cancelling their admit cards also. And we have said also there may be some, but everything is not filtered at 5 lakhs applications are there. It may not, but ultimately, if anyone is there, we'll cancel. And because this is the order of your lordship's order, which has been upheld,
That is
they
what I'm
cannot
saying.
be treated. They cannot be accepted at all.
That is what I'm.
There's even if I miss anywhere, let's assume if I miss anywhere, that here I'm missing. He has got it.
At the time of verification.
At the time of verification, I will do it.
But that is what I'm saying. If I appear in the examination,
If you appear in the examination, Supreme Court
kindly
will throw you in the
cancels
can-
me. Kindly
in
cancel.
Jamuna.
I will get an opportunity. I want to go to Jamuna.
You
I
know,
want to go to, but after appearing in the examinations, not like this.
up
No, if I miss examination, manual, I will not be able to appear. 156 has not been accepted.
Yes.
156 has not been accepted.
See, below.
156 has not been accepted.
Table 1.
Let us, yes, see.
Just a minute.
156 of the writ petition.
Supreme Court order. Lordship is taking the Supreme Court order, always paragraph.
3rd April 2025 order.
Yes. 156 and second volume order.
Paragraph,
Paragraph 25. Page 1.
just a minute.
First similar, in the written submission filed on behalf of WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who are.
Just a minute, just a minute.
Lordship, kindly see, these are the
Yeah,
submissions which have been
25.
recorded.
But in the written submission filed on behalf of the WPSSC in this court, 2 tables have been furnished. Table 1 pertains to candidates who earlier jumped rank were appointed despite not being in panel. The details are assistant is 74 rank jump, out of panel but still appointed at 111. Assistant teacher for class 11, 12, 20, out of panel but still appointed 18. Well, this is the 9 and 10, that's the written answer. Then table 2 fund is a WSC for candidates who are appointed by manipulating the OMR sheets. Table 2 is as under.
Table two extent
Now,
teachers plus
OMR score mismatch for CBI image.
where you are getting the manipulating this, yes.
Yes. Who are appointed by manipulating the OMR sheets.
But these are the submissions.
No.
I'll show. I'll show. These have not been accepted.
Tainted. What is tainted?
Kindly see paragraph 28.
Therefore, kindly see and answer 952. Then assistant teacher, candidate who are appointed, I will not show. Assistant teacher for class 9 answer. Then in another it is a file on camera in this code. It is claimed that on further verification, the following details of the candidates who either jumped rank or were appointed despite not being in the panel came to light. Rank jump 74, loss of particular.
Table 2.
Next.
Paragraph 26.
Paragraph 26. 26. Table A, table B.
Yes. Yes.
Therefore, these are tainted. But why the Supreme Court has said all tainted
Kindly
teachers
reads.
should be
Kindly reads.
removed.
Kindly reads on.
Just 1 minute.
Yes.
I mean, you honest for
No, back second. I understand. I know.
3 minutes. Therefore, these
Says
all
to avoid.
were terminated. Number 1. Then the Supreme Court will file the applications for all. I mean, both file the applications for group 910, 910 C and SC. Supreme Court has said, we are allowing you to keep this for the timing. Number 1, up to 31st December, you have to complete the examination. Number 2, no tainted candidates should be allowed to apply. First, he has not challenged the termination. Second, he has not
There is no
challenged
termination as such, as of today.
Cancellation of appointment.
There is nothing. Nothing.
by Supreme Court order.
Nothing. That is by Supreme Court. Thereafter, it has not been indicated to us. Where is the cause of action? How will I come and say?
Don't come. Don't be excited.
In this matter, don't raise your voice.
Second, my lord, second is
He was my leader. He knows everything.
Lordship has already pointed out, you have not been allowed to join. After 31st December, why did you not?
Where is that order that candidate 17th? This is 17th April.
17th April is page 160, 175.
175. 170.
Now, my lord, kindly, before going there, kindly comes to
Just a minute.
page, paragraph.
সারাদিন শুনবে বলে।
না একটা কিছু না আমি শেষ করব বলেই দিয়েছে শুন
My lord, may I read it, madam? We are inclined to accept 175.
17th April order.
Page 175.
Yes. The examination and the entire recruitment process shall be completed by 31st December.
31st December 20.
Then paragraph 3, the state government and the applicant.
The transfer shall file the respective evidence by 31st May 2001. Enclosed there is copy of the advertisement for the place recruitment as well as the civil therefore so as to ensure completion of the recruitment process by 31st December 2000. In case the advertisement is not performed by transfer are not filed by the court, they will have to put it order to the pass. To clarify this order cannot be read as a conferring in itself. We are not inclined to accept the prayer in the present.
TD.
No. Oh.
But where is the
Yes, sir. We are inclined to accept at the top line of the order or of the order first beginning. We are not inclined to accept the prayer made in the present application so far as not found to be tainted subject to the following. And last,
so this is the prayer made by the West Bengal Board of Secondary Education,
board.
Yes.
permitting them to permitting the untainted to work.
Now,
That was accepted.
they filed an application to allow everyone. Board Supreme Court has said no. Kindly come to the last lines. We have.
That is CD, that is CD, that is CD.
To pass this order in respect of action not found to be tainted if that student undergoing study.
Which paragraph?
No, last part one. Page 176.
That is in connection with group C, group D.
No, after that. What has prompted us to pass this order? In respect of the assistant teachers.
Just it. Place it, which paragraph?
Just come to 176. That's what come to 176.
You are on the order date 17th April 2025. Passed on miscellaneous application 709 of 2025.
Yes.
Which paragraph you are relying upon?
Let this page kindly come to this page.
Yes.
176.
There are 1, 2, 3, 4 paragraphs.
After that, we clarify that these orders shall not be read as a confirming any special right or advantage on the associate teacher in so far as the fresh recruitment process is concerned. That is untainted. Then we are not inclined to accept the prayer in the present application so far as non-teaching posts in group C and D are concerned, as the number of appointees specifically found to be tainted in the said group is substantively high. And secondly, what has prompted to us to pass this order in respect of assistant teachers not found to be tainted is that students undergoing study presently should not suffer on account of the lack of teacher and a lapses and failure, which have resulted in the order passed by this court.
So that after this this observation, we were not permitted. After this observation, you were not permitted. After this observation, you were not permitted to to work till
I am not, Malad.
which goes to show that you are considered as tainted care.
That is the interpretation. We have not been informed of anything.
Yes.
We have not been informed. This is for the first time it appears that our names have been taken into account. And Mr. Bandyopadhyay has shown Malad paragraph 25 kindly comes to paragraph 28 of that Supreme Court. That your lordship is seeing the Supreme Court from your lordship's brief, Malad. Your lordship's brief, Malad. Your lordship is having Supreme Court alada kore. Yes, that one.
Yes, there are only 363 paragraph.
Now, Malad, no, not 360. The Honorable Supreme Court judgment, main judgment.
Yes.
Paragraph 28. Kindly see paragraph 28. Because Mr. Bandyopadhyay has shown, Malad, the submissions, which starts from paragraph 25. Submissions, the charts. Now, in view of the fact that the charts were contradicting and the charts have been subsequently improved and all these things, that is the finding of the Supreme Court. Kindly see what the Supreme Court holds. Paragraph 27. From that, at this stage, we would like to kindly skips paragraph 28 at internal page 31 of the judgment. I'm sorry, Malad, I'm traveling with Lordship, Malad.
Yes, paragraph 28.
We may have accepted this argument.
Yes.
If WBSSC had the original physical OMR sheets or the mirror copies of the OMR sheets. So the previous arguments are not being accepted. Chart also. However, WBSSC accepts that they do not have the physical OMR sheets as they were destroyed in terms of Rule 21 of the classes such and such, which required retention of OMR sheets for only 1 year. Rule 21 of the such and such, it is quoted. Thereafter, admittedly, the OMR sheets were applied for non-teachings. Well, I'm skipping that. That relates to non-teaching. Thereafter, paragraph 30. Moreover, given that the recruitment process was ongoing even after 1 year validity period of the panel, there is no justification for destruction of OMR sheets. It is apparent that the time period specified in Rule 21 was coincide with the time period specified for validity of the panel. Further, WBSSC did not maintain the mirror copies of the OMR sheets in their computer records. Thus, the destruction of the physical OMR sheets and the failure to maintain scanned images of the OMR sheets are significant factors which were rightly taken into consideration by the High Court. We concur. Thereafter, paragraph 31 that I have already placed, WBSSC has also tried to justify the extension of the term of the panel as noted above. The term period of 1 year specified in such and such for destruction of OMR sheets coincides. There is no doubt that the counseling process and the appointments made to the post of assistant teachers were made after the expiry of panel. That matter I have indicated to your lordship what is the list that they have given before the division bench. They have not been put in the tainted list. It is illegal. This is illegal and contrary to the rules. Reliance on the orders stroke judgments of the High Court in stray cases of rank jumping, where the High Court directed to appoint candidates after the expiry of validity panel, would not have any significance. So therefore, Supreme Court deprecates the persons who have been appointed after expiry of the panel, and the list is there before a lordship, and I can substantiate at least one candidate, and I can substantiate the entire list. None of the names of this list who have been appointed in the 8th round of counseling, which was held on 3rd August 2020, have been included in the tainted list, and we are outside. We have been included.
Yes, that's all.
Now, my lord, kindly, this list I have shown to
Yes,
you.
yes, Mr. Sen.
And my lord, another point, 1%, my lord, another, my lord, item number 4 is different. Kindly, my lord, takes up item number 4. Item number 4. 7 and 4 is on the same. Kindly it gives me 1 minute time. I'll place item number 4 because there the affidavit of the SSC says in the first round of litigation that these persons are not tainted. It says I'll rely upon that one. 19. That is also 4 is also 19. And the only distinction feature between 910 and 1112 is in 910 the OMRs were published. But in 1112, the OMRs were directed to be published by the Honorable Justice Abhijit Gangobadhyay. We moved, my lord, an intra-court appeal that was stayed, and the Honorable Supreme Court directed that only the names will be published, the OMRs. So that 1112 candidate as of today do not know what is their OMRs. There is a direction in the Honorable Division Bench presided over Justice Devanshu Basak judgment to publish the OMRs.
Item number 7 is relating to 910. Basically, points are same. What your lordship is interpreting, paragraph 363 of the division bench order. Your lordship's view is that is only illustrative. That is not exhaustive. But I would like to just read paragraph 363 with the Supreme Court judgment to show that that 3 becomes exhaustive because of only the fact that the Supreme Court was of the view that there was no original MR sheet. Also, OMR sheet, there was no original and the originals were destroyed. So therefore it was not, and there were several disputes raised with regard to the scan and the mirror copies.
Yes.
So therefore it cannot be said with certainty that other irregularities concerning the OMR sheet. So therefore, what could be said is that blank OMR sheet. That is something which is conclusive to make it within the category of tainted. But whether the other irregularities relating to the OMR sheet will also fall within the tainted category, for that one has to come to a conclusive conclusion. Yes, this is the copy which is produced in the original, or it is exact copy of the original.
Your whether the petition is working?
No, December 31. That is
Not
there.
working.
Not working.
So what steps you did?
But that I understand. But here, my lord,
No, what you understand? Why steps were not taken?
yes, well, that is what I wanted to answer, my lord. Your lordship.
That
see,
others are permitted, why you are not permitted?
but that I was not part of the Supreme Court.
No, that
judgment
is
at
not
that point of
required. You are
time.
not part of. When you are not permitted to work till 31st of December, you should have approached the authority for taking steps that why I am being
But
not,
that
I am not being permitted to work till 31st
because then they will show that this
of, 31st of December 2025.
that the Supreme Court ordered that is going to be cited.
Yes, so therefore you are being treated as untainted from the after the list was prepared containing names who are permitted to work till 31st December.
Well, that this does not categorize or segregate the
It
tainted
goes
or
to show that
untainted.
you are being treated as tainted candidate.
Well, your lordship will kindly
Only those candidates who are treated as only those candidates who are treated as untainted were permitted till 31st of December in terms of the order dated 17th
But,
of April.
Well, with the greatest of respect, but that division, if it was already possible, then the Supreme Court would not
For that, Mr.
would
Sen,
not have cancelled the entire process.
There was no requirement to wait till publication of this list.
So, because I have already got the admit card before publication of the list, they treated me as untainted, and they gave me the admit card. So then, my lord, where is my cause of action? Very well, I was not working, but provision was made for appearance in the next exam, next recruitment process. I was allowed to participate in the next recruitment. Admit card is already given. But how will I know that a different list of untainted and tainted will now be segregation?
Approach the Supreme Court in an IA in a pending matter.
Well, kindly.
Since Supreme Court is in session
No,
of the matter, why court will consider?
Therefore, now comes the balance of convenience, my lord. Your lordship will see if the exam is on Sunday. So, my lord, if even after the exam, my fate can be decided. Even after the exam, my fate can be decided. My answer may not be considered or whatever. But today, if a firm decision is taken without there being active segregation of this distinction of tainted and untainted, then, my lord, my right will be lost forever.
Yes.
There is a question of balance of convenience. But here, that is why I just want to refer to 363, why that is exhaustive. That is exhaustive because of the Supreme Court judgment. Just the paragraphs which Mr. Lahiri has placed, that is extremely relevant. Kindly just see once, your lordship kindly sees paragraph.
Yes, that has been placed. I have seen.
No, I am not on that. I am saying, I am therefore saying that Supreme Court definitely came to the conclusion that first of all, there is destruction of original. Second, whatever copy is being produced, there is substantial cloud. If there was no substantial cloud, then.
So in your case, admit cards were issued, then thereafter you are enlisted as tainted.
My case also. Thereafter, I have been enlisted as and as a yes, admit card has been cancelled. Cancelled. Has been cancelled. That is what I have challenged here, my lord.
I have not shown the cancellation of the admit cards. I can show it in the cancellation screenshot.
Is any addition by anybody?
Item number.
I rest my thumb.
This candidate. This particular malord teacher was malord working, and her services were not terminated intact, but has been terminated pursuant to order of the Honorable Supreme Court. In that matter, malord, an affidavit was filed by the
Supreme Court 3rd of April.
Yes, yes. Not working after 3rd of April. Now, page 62 is the affidavit which has been filed by the SSC before the single bench, which ultimately went to the Supreme Court. There, the SSC had said, but what the mismatch of marks, my lord, were there in respect of this particular candidate was to the tune of only 1 mark. The OMR sheet, if evaluated, would come to say 20. I have been given, would come to 19. I have been given 20. That is the only one mark. The SSC said in respect of this particular candidate kindly comes to, may I just place paragraph 63, page 63, first paragraph. Second paragraph. Secondly, in respect of
your that writ petition.
of yes, item number 4, madam. But this was never placed nowhere in the previous rounds of litigations. Those are matter on the points of principle.
এই দাও তো page
Supreme Court annex only this. Now, my lord, page 63. This is the affidavit in respect of 910 candidates. Subhamoy Bhuiya was the 910 candidate, one of the 910 my lord, writ petitions where it was been heard before the Honorable Justice, my lord, Vishwajit Basu. This affidavit was placed.
This is item number 4.
4, yes.
Page 63.
Page 62 is the affidavit. I will be placing from page 63 and 64. The order, by an order dated 6th February, the court was, the commission was directed, page 63, it is recorded, on 6/2/2000.
Affidavit by whom?
By the SSC.
Yes.
On 6/2/2023, in course of the hearing the instant writ petition, the court was pleased to direct learned advocate appearing on behalf of the commission to file a report in the form of affidavit to the modality to be adapted by the commission to exercise its powers under Rule 17 of the such and such.
Here no admit card was issued.
Yes.
Here no admit card was.
Yes, admit card issued, cancel. All matters. Admit card issued, cancel.
All matters.
All matters. Admit card, I can show one of the screenshots. I have not shown before, Lordship. I will show one of the screenshots. Here, that is February 2023. Why it was directed? Why you have not?
Which paragraph you are reading?
Paragraph 3. To give the background, why this affidavit has been given. I'm sorry, ma'am. I'll just skip over I'll come to the relevant part. This is only to give the background, since your Lordship is reading each and every paragraph. Rule 17 was the rule which empowers the SSC to withdraw the recommendation even after the appointment. That was issues with regard to Rule 17, and subsequently now the issue has been settled. It has not been settled, though it has not been taken up. The Supreme Court had directed this Honorable Court to settle. This Honorable Court didn't settle it. We have gone to the Supreme Court and lost, so therefore no point. Now, kindly comes to paragraph 4. In reply to the above, I submit as follows regarding the steps contemplated to deal with the candidate under such and such. Firstly, it is respectfully submitted that the marks of 15 candidates were increased by 1 mark in compliance with order of the Honorable Court, which I am not. Next is the category where I will fall. Secondly, in respect of 937 candidates, it is found that the marks difference vary from 1 to 53. Considering the large number of cases to be handled, it is respectfully submitted that SSC proposes to move from the most palpable severe irregularities to the least severities. That is, from the case where the marks difference is 53 to the case where the marks difference is 1. 1 is the petitioner before Lordship. In the latter case, it is respectfully submitted that the further due diligence is called for and SSC will deal with such cases at the end. So therefore,
the marks difference ranging from 53 to 1.
Now kindly comes to page 76. Yes. Affidavit of the SSC before the division bench. This is the affidavit that I have shown your Lordship. This is also annexed here.
But somehow the issue has to be put to an end.
Yes, it has to be put to an end.
Therefore, today
allows me to participate and says that
therefore,
even if you are
today,
appointed,
when the Supreme Court has said and the Commission has issued a list, and the issue is in session of the Supreme Court, at this stage, court is not inclined to interfere with this.
I understand your Lordship's binding, but balance of confidence. I
The
will
entire,
go out.
now the court, in that event, if I accept your contention, these 2018 candidates who were enlisted as tainted, one after another, all their credibility has
There
to
are
be
categories.
considered.
But
It's not
this
possible.
exercise has to be
Sorry.
considered at one stage or not. This exercise has not been done. And one point, my lord, I have missed, my lord. My lord, 116, my lord.
Just one point.
Yes. But only, sir, পূরণ করো, এক সেকেন্ড, এমনিতে হারিয়ে দিচ্ছে দাঁড়াও।
রেকর্ড জাস্ট আমার রেকর্ডটা দরকার আলটিমেটলি সুপ্রিম কোর্টে যাবে তখন আমাকে
না, না, আমি
you were there, you didn't argue, Mr. Bandyopadhyay. No, no. Well, one question is this, Miller.
Yes.
According to CBI report, it is a case of mismatch. Right? Since it is a case of mismatch, we have
OMR mismatch.
OMR mismatch. That OMR mismatch, that is the reason we have treated it as a tainted. Number one. Number two, if his submission is accepted, can you see, according to OMR marks, according to image received from CBI, then it's 34, right? And server
In
marks,
whose case? 34?
in this case. Server marks was,
Not in this case, 7.
I am according to your case.
মানে প্রথমটা আমি
I mean, I am talking about.
4-1 এক মাস সম্পাগস্ত, হ্যাঁ সম্পর্ক বলুন, হ্যাঁ সম্পর্ক।
If his contention is accepted, then cutoff mark will be 68, so that he can call in the interview. And if CBI is accepted, then his cutoff, his mark is 67, he will not come, at all will not be called. First thing, let us, am I clear to Lord, is that I am treating everyone, if the mismatch 1, 2, 3, it doesn't matter to me. CBI has said it's a mismatch, I am treating him tainted. I am treating him tainted. That on the basis of the CBI. Number two, even if his argument is accepted, then even then he cannot be allowed to by the court because CBI marks has to be taken into account. Then he is not coming to the cutoff. Less one cutoff.
চার্জশিট মেলার CBI has said
Yes,
something
please.
else.
CBI is saying that it's mismatch. You are
I
treating
am
it as
accepting
mismatch.
it's a mismatch.
That OMR mismatch.
OMR mismatch.
Then what on cutoff marks? What is your submission?
Cutoff marks, my lord. First of all, if it is a mismatch, let's assume that he is more than the cutoff marks. Even in that case, I will treat him as a tainted. His case is one number difference, right? He is saying whatever the number one, if his one number is taken, then he is coming to the cutoff mark. If the CBI number is taken, then he is less than cutoff mark, one number.
No, my lord.
Because I have to
Way
say,
above.
can you record this?
Way above.
When it will go to Supreme Court, then I have Supreme Court will
Way above, way above.
In case of suppose there are 50 candidates. In case of all candidates, these separate facts are to be narrated.
No, I don't think so. Malad, kindly
Has to be,
see.
has to be.
No,
At one point,
my submission is this. What is his submission? My
Has to
submission is very clear. My submission is
justice will be done.
if is a mismatch is there, whether you have got 100 or you have got 50, it is immaterial to me. You may be brilliant, but mismatch is there. CBI is giving you the report is a mismatch. Finished. I am treating him as mismatch. Tainted.
Now regarding cutoff marks, please repeat your submission.
Lord, what is saying
Page
That
56.
if suppose a cutoff marks is 50,
if his contention is taken, the Malad is এখন আবার travel করে এলো।
এই যে এখানে দেখো না, এই তো লাগিয়ে রেখেছি আমি রাহুল, এটা দেখিয়ে বল, এইখানে লেখা আছে তো, এই যে আমার নাম্বার শম্পা ঘোষ,
ছেড়ে দে এসব। Malad,
এইখানে
leave aside,
88
Malad. No, because I have to in that I have to file an affidavit.
That's what I'm saying.
Leave aside. Kindly record my submission that his case, I have since it is mismatch. Whatever the number he has got, it doesn't matter to me. It's a mismatch. CBI has given the report. I am treating you as a tainted.
1 marks mismatch is
Well, anyway, that is I
alleged, and that is also a question was erroneously made. They have said in the RTA application that there may be two provable
first
answers.
Malad, let us be very clear. Let me very clear to your lordship. Let me very clear to your lordship.
এটা চার
Let me very clear to
ওটা এখানে রাখো ওটা সরিয়ে
সোমনাথ,
নিও না,
সোমনাথ।
ওখানে রাখো
সোমনাথ,
we are proceeding on the
ফার্স্ট ও প্লেস করলো ওইটা দাও
সোমনাথ, সোমনাথ,
We are proceeding on the basis of the CBI
20,861,
report.
20861.
We don't have much discretion to do. We don't have much discretion to do. We are proceeding on the basis of the CBI report. Whatever the CBI has given the report, and on that basis, the entire proceeding has been done. This court, Supreme
Now,
Court,
today, if you enter into the, if you make submission inviting the court to enter into the issue of cut-off marks, then I need to give direction for filing.
but
Then I need to give direction for filing affidavit.
my lord, what I am submitting,
It is there in the Supreme Court
But
order,
if I-
Sonali Das order. Supreme Court has said that everyone has to be, it has to be heard.
no, Supreme Court order, can you see?
Sonali Das,
Yes, I know that.
I am in
appeared
Sonali Das category, 33.
No. What has happened in that matter? In that matter, the Sonali Das filed the writ petition prior to the delivery of the judgment and other things.
My case is also that. I have also
You are
filed.
coming with a new writ petition.
No,
right?
this is the new writ petition. The previous writ petition has not been dismissed and it is in
You have not
petition.
made an application in that writ petition.
Yes, I have made.
Now, my lord, kindly come to page 120.
I know my case, my lord. I know my facts, my lord.
You know, I know. You know. Only I do not.
You know that I know. You know that I know.
You know that I do.
You know that I know. My lord, we have
This
approached
is my
earlier.
submission, can you record that?
Item number 4, I can show, my lord, we have appeared and my writ petition number would be reflected from the order passed by the Honorable Justice Devanshu Basak division.
petitioner উপর একসঙ্গে করে দেবে।
And my lord, one page, my lord,
In this writ petition,
page 123, FCBI affidavit, only 20 are blank OMRs.
writ petitions are filed
Big matter. যাচ্ছি আমি
Questioning. publication of list containing names of tainted candidates in a memo dated 30th August 2025 issued by the Secretary West Bengal Central School Service Commission. The list dated 30th August 2025 features names of 104 names of 1804 candidates who have been declared as tainted candidates. In connection with their participation in first state level selection test 2016 for classes 9, 10, 11 and for classes 9 and 10 and 11 and 12. 2016 for classes 9 and 10 and 11 and 12.
কালকে সার্থকে দিতে গিয়েছিল সার্থক আজকে সকালবেলায় চলে গেছে হয়তো আপলোডেড রুম
Next part. At the outset, it needs to be recorded that in terms of order dated 28 August 2025 passed on special leave to appeal within bracket C number 23784/2024 within bracket Bijoy Bishwas and others versus State of West Bengal and others. list was said list dated 30 August 2025 was published by the West Bengal Central School Service Commission, within bracket hereinafter referred to as commission, quote unquote. Next slide. As per cases, as per case presented on behalf of the petitioners, they either participated in first SLST 2016 for classes 9, 10 or first SLST 2016 for classes 11 and 12. But they lost job in terms of the judgment of the Honorable Supreme Court dated 3rd April 2025, passed on civil appeal arising out of special leave petition within bracket civil close bracket 9586 of 2024, State of West Bengal versus Boishaki Bhattacharya Chatterjee and others. Since inter-selection process was declared null and void on finding egregious
May I assist you, Lordship?
illegalities. Stop. According to the petitioners, after recruitment notification was published,
May 2025. She wants the date of the recruitment, second recruitment notification.
30th May, where is the notification?
Yes, that is at page 179 of the second volume. That order is 17th April.
On 30th May 2025, on promulgation of the West Bengal School Service Commission, within bracket selection for appointment to the posts of assistant teachers for upper primary level of classes, within bracket except work education and physical education close bracket,
Upper primary.
classes 9, 10 and classes 11 and 12 close bracket rules 2025. Herein are referred to as said rules of 2025. They were issued admit card, but based on admit cards, but based on list dated 30th August 2025, issued by the commission containing names of tainted candidates, their admit cards were cancelled,
That cancellation is 257, 258.
prompting the triggering present writ petitions. Stop. Next paragraph. Mr. Anindo Lahiri, learned senior advocate, and Mr. Shakko Sen, learned senior advocate, representing some of the petitioners, have placed reliance on the judgment dated 22nd April 2024, passed by the Honorable Division Bench, on batch of matters, first one being WPA 30649 of 2016, Boishaki Bhattacharya Chatterjee, within bracket Chatterjee and others versus State of West Bengal and others. In order to contain that petitioners are not coming under the category of tainted candidates as defined in paragraph 363 within bracket small Roman 4 of the said judgment dated 22nd April 2024. So it is further contended that as per observations made by the Honorable Division Bench in the judgment dated 22nd April 2024, persons who had been appointed outside the panel or persons who were appointed after expiry of the panel or who submitted blank OMR sheets ought to be treated as tainted candidates, but petitioners are not coming under those categories. Therefore, cancellation of their admit cards by publication of list on 30th August 2025 was not warranted, was not warranted. Stop.
Thereafter, our division bench.
In addition thereto, reliance is placed on observations made by the Honorable Supreme Court in the judgment dated 3rd April 2025, passed in Boishaki Bhattacharya Chatterjee, is relied upon, wherein it was discussed it was not significant so far stray cases of rank jumping and direction given by the High Court to appoint candidates after expiry of the validity of the panel. Stop. Based on which based on several considerations, including rank jumping and appointment of candidates after expiry of validity of panel, ultimately conclusion was derived in paragraph 45 of the judgment dated 3rd April 2025 by the Honorable Supreme Court. Wherein it was held that there was no valid ground or reason to interfere with the direction of the High Court that the services of tainted candidates, where appointed, must be terminated, and they should be required to refund any salaries and payments received. In other way, it is submitted that observation made by the Honorable Division Bench in the judgment dated 22nd April 2024 especially in paragraph 363 within bracket 4, Roman 4 was not interfered with. Therefore, identification of tainted candidates needs to be based on three categories as delineated in paragraph 363 within bracket 4 and not beyond this.
Division bench is at
Stop.
page 238. Division bench that I have relied upon, Justice Somen Sen, is at page 230. Huh.
Next paragraph. On the contrary, Mr. Bandyopadhyay, Mr. Kullan Bandyopadhyay, learned senior advocate representing Commission, submits that apart from aforesaid three categories of tainted candidates, as described in paragraph 363(4), of the judgment of the Honorable Division Bench dated 22nd April 2024, other categories of tainted candidates involving rank jumping, candidates identified by CBI were taken into consideration by the Honorable Supreme Court in the judgment dated 3rd April 2025 passed in Boishaki Bhattacharya Chatterjee Supla, as it emanates, as it appears from paragraph 25 and 26 of the said judgment. Stop. It is specifically submitted list of tainted candidates dated 30th August 2025 is prepared based on CBI based on report of CBI which says there are cases of OMR mismatch and commission found them as tainted found them as tainted, and those candidates were included in the list dated 30th August 2025. According to the commission, categories of tainted candidates ought not to be confined to the categories as contained in paragraph 363 within bracket 4 of the judgment of the Honorable Division Bench dated 22nd April 2025. Stop. Next paragraph, it is also submitted on behalf of commission that an order was passed by the Honorable Supreme Court on miscellaneous application number 709 of 2025 in civil appeal number 4805 of 2025 within bracket West Bengal Board of Secondary Education versus Boishaki Bhattacharya within bracket Chatterjee and others. Whereby the Honorable Supreme Court permitted
Once.
only those assistant teachers who were not found to be tainted. To continue to function as assistant teachers till 31st December 2025. Stop. Authorities, in terms of the order of the Honorable Supreme Court dated 17th April 2025, finding only identifying only untainted teachers, permitted them to work till 31st December 2025, not others. None of the petitioners before this court today are permitted to are presently working as assistant teachers in their respective schools based on their selection in connection with first SLST 2016 for classes 9, 10 and 11 and 12. Therefore, petitioners may not be regarded as tainted may not be regarded as untainted teachers. Next paragraph. Reliance is also placed on two orders of the Honorable Supreme Court, one dated 28 August 2025, passed in special leave to appeal within bracket C number 23784 of slash 2025 within bracket Bijoy, Bishwas and others versus State of West Bengal and others. And order dated 29th August 2025. Passed in special leave petition within bracket civil close bracket diary number 46049 slash 2025 within bracket Vivek Paria and others versus the State of West Bengal and others. So, it is contended that in terms of these two orders dated 28 August 2025 and 29th August 2025, list dated 30th August 2025 was published by the Commission containing names of tainted candidates, and both the matters are pending consideration before the Honorable Supreme Court. Next paragraph.
Lordship,
Having considered the next paragraph. Reliance is placed on paragraph 363 of the judgment of the Honorable Division. Reliance is placed on paragraph 363 within bracket 4 of the judgment dated 22nd April 2024 passed by the Honorable Division Bench in Boishakhi Bhattacharya Chatterjee Supra on behalf of the petitioners in order to lay stress that only candidates who were appointed outside the panel comma candidates who were appointed after expiry of panel and the candidates were appointed after submitting blank OMR sheets only need to be regarded as tainted candidates and petitioners are not coming within those three categories. But on perusal of
computer
extent of egregious fraud and illegalities, or but on consideration of egregious illegalities and fraud as found by the Honorable Supreme Court in the judgment dated 3rd April 2025 passed in Boishaki Bhattacharya Chatterjee Supra. Categorization of tainted candidates as made by the Honorable Division Bench in paragraph 363 is probable is probable categorization comma there can be other good reasons for finding candidates to be treated as tainted. Stop. In consideration of gamut of illegalities and irregularities found by the Honorable Supreme Court and Honorable Division Bench as it transpires from the judgment dated 3rd April 2025 and 22nd April 2024. It is permissible to infer that there are different categories of tainted candidates beyond the stipulations contained in paragraph 363 of the judgment of the Honorable Division Bench dated 22nd April 2024. Stop. Today it is submitted on behalf of the Commission that based on that as per CBI, there are cases of OMR mismatch and which and the candidates involved therein are identified as tainted candidates, and this court does not find fault with such offense. Next paragraph. Moreover, not a single petitioner before this court were permitted to function as assistant teacher in terms of the order of the Honorable Supreme Court dated 17th April 2025, passed on miscellaneous application number 709 of 2025. Within bracket West Bengal Board of Secondary Education versus Boishaki Bhattacharya Chatterjee and others. Stop. With a said order dated 17th April 2025, assistant teachers for classes 9, 10 and classes 11 and 12 not found to be tainted were permitted to function as teachers in their respective schools for the academic interest of the students taking note of that lack of teachers and taking note of lapse of teachers in the school. Stop. But at the same time, Honorable Supreme Court framed time schedule for bringing the fresh selection process to its logical conclusion. That was by 31st December 2025. As per said order dated 17th April 2025, since only untainted teachers were permitted to work as assistant teacher till 31st December 2025, excluding petitioners here, excluding the present petitioners. This court has no hesitation in refusing their contentions, claiming to be untainted teachers. Stop. It needs to be recorded herein that when in terms of the when untainted teachers were permitted to continue their service till 31st December 2025, just after the order was passed on 17th April 2025. Present petitioners did not raise any demand, at least that is not demonstrated before this court. Semicolon. Stop. Next paragraph. Moreover, moreover, it is important to note here that the Honorable Supreme Court in order dated 28 August 2025 passed in Bijoy Vishwas Supra recorded the submission of the learned senior counsel appearing for the commission that the list of tainted candidates who were selected and whose selection was set aside by the High Court and confirmed by the Honorable Supreme Court would be placed in the public domain in the website or on the website of the commission within 7 days. Stop. That order was further considered by the Honorable Supreme Court in the order dated 29th August 2025 passed in Vivek Paria Supra and following observation was made which runs infra. Get out. Next paragraph. Both the orders dated 28 August 2025 and 29th August 2025 now orders dated both the special leave petitions being special leave to appeal within bracket C number 23784 of 2025 and special leave petition within bracket civil diary number 46049/2025 are pending consideration before the Honorable Supreme Court. And in connection therewith, list dated 30th August 2025 was published, containing names of tainted candidates. Stop. Therefore, this court finds these are not fit cases where court should interfere with the lists dated 30th August 2025 containing names of tainted candidates. When the Honorable Supreme Court is in session of the matters as aforesaid. Next paragraph. Hence, writ petitions stand dismissed. However, there shall be no orders to post urgent jurisdiction.
Well, 2 points, my lord, that the expiry panels are being continued and not included in the tainted list in view of paragraph 31 of the Supreme Court order, my lord. Kindly, well, I have made submissions that these persons who are expiry panel candidates have not been included in the tainted list, and my lord, in respect of which paragraph
Expiry panel candidates.
paragraph 31 of the Supreme Court order, where the Supreme Court has severely deprecated these persons are continuing. I am given the list also.
Paragraph 31.
31.
Yes, I have considered paragraph 31 that
Yes.
is rank jumping.
Rank jumping, but these candidates are
And
continuing.
where the High Court directed to appoint candidates after expiry of the validity of the panel, but
These are
the Supreme Court found this is not a significant issue.
This
As
is
it
a
is
significant.
stated,
This is a significant issue. These illegalities and contrary to rules.
jumping where the High Court directed to appoint candidates after expiry of the validity of the panel would not have any significant impact.
Yes, significant impact. Some of these persons had secured
It would not have any significant impact.
impact. That is, some of these candidates had shown orders by which they were directed to be appointed. That didn't have any significant impact, because these candidates, 1 or 2 candidates, they had orders passed by the honorable.
I have recorded your submission based on observation made in paragraph 31 in my own way.
31. Lashe also record that persons who are expired, because this will be
not that I have ignored your submission in connection with paragraph 31 of the judgment dated 23rd of April 2020.
only one submission was that these are expiry panel candidates. They are also being continued. Kindly record one line. This is my contention, and this will be appearing from the date.
Expiry panel?
Expiry, after expiry of the panel, because we were appointed in 2018. Panel was valid till end of 2019. These candidates, counseling was done in August 2020. So after expiry of panel. And
So
these,
they were allowed to continue.
they are allowed to continue. They are not even in the tainted list. Yes, they are in the CBI list. Everyone is there.
আচ্ছা ওখানে ওর যে সাবমিশন
Page 170.
রেকর্ড করেছে সেখানে একটা লাইন অ্যাড করো তো। Those candidates
Yes.
please allow me to record it. Yes. Some of the candidates some of the candidates were allowed to continue, but they were appointed after expiry of the
Panel.
relevant panel.
Yes. List, page 170.
After expiry of the panel.
Panel.
After expiry of the panel.
List is 117.
And their names do not feature
In the
in
tainted.
the list dated 30th August 2024.
We have excluded anybody whose name appeared in the CBI's list.
And item number 4, Lordship is giving another judgment, or would be item number 4, 1 marks difference that your Lordship can, because that is a Sonali Das judgment of the Honorable Supreme Court, which
No, I have
says
considered it as a whole. Separate consideration is not required.
because at the end of the day, after appointments are made, this will again be challenged, saying that look, expiry panel candidates have been included.
তোমার কোনটা কোনটা লাগবে দেখো এটা কোথাও পাবে না, এটা পরে হয়ে যাবে। আর এই যে সেটা আউটটা করে দিলাম পরে হয়ে যাবে। বলো বলো সুপ্রিম কোর্ট। হ্যাঁ হ্যাঁ সব আছে।
আজকে আইটেমের সার্ভিস
আমার থেকে দিয়েছি করতে সময় লাগে। সুপ্রিম কোর্টের জজ
অ্যাডভোকেট সাতকোশে সার্ভিস নেই 7 নম্বর আইটেম 20,877।
এইটা হলো ডিভিশন বেঞ্চে তুমি এখানে এটা পেয়ে, তারপর হচ্ছে 17th এপ্রিলের যে অর্ডারটা সেটা এখানে পেয়ে যাবে। 17th এপ্রিল অর্ডারটা এখানে
Lordship requires my assistance for that.
if I require further then I'll call. এই দুটো পাচ্ছ তুমি, এই দুটো অর্ডার তোমায় দিলাম তো, আর কি লাগবে?
লাস্ট
আর নোটিফিকেশনটাও যেটা বললো লাহিড়ী, একটা রুলসটা 2025, ওই রুলসটা ওই সুপ্রিম কোর্টের অর্ডারে একটা জায়গায় সেট আউট করা আছে, আমি আগে পয়েন্ট আউট করে রেখেছিলাম। এখানে এটা না, এই পরে ওখান থেকেই তুমি নোমেনক্লেচারটা পেয়ে যাবে, এই রুল বলে বলা আছে, এখানে রুলটা পুরো বলা আছে, নামটা আছে কিন্তু খুঁজে পেতে যদি দেরি লাগে। ঠিক আছে, সবকটা পিটিশন একসঙ্গে ধরে নামি।
পাঁচ সবকটা এখানে খেতে দিতে বলেছে। এটা 4 নম্বর।
এটা লাস্ট পেজ অফ দ্য সুপ্রিম কোর্ট অর্ডার ডেটেড 3rd এপ্রিল খুলে বেরিয়েছে, পিন করে দেবো।
এটা একটু এটা লাস্ট পেজটা খুলে
দিয়ে মেলে আগে পাঠিয়ে দেবো।
আইটেম নাম্বার 8।
কবে দিয়েছেন?
হ্যাঁ।
4, 5, 6, 7।
Kindly see Lordship's earlier order.
সব একসাথে সব ট্যাগ করো, সুন্দরভাবে বলো ট্যাগ করো। সার্ভিস গুলো ট্যাগ করতে হবে, যা আছে ট্যাগ করো।
তারপরে এটা কিছু দিয়েছে পড়াশোনার পরে
সার্ভিসটা ট্যাগ করো।
স্কুল থেকে কি দিয়েছে?
খুব ঠান্ডা লাগছে, ভালো লাগছে। আরে বৃষ্টি হয়ে গেল না?
রিপোর্ট
pursuant to that on 20
pension file is lying with the school or the
PI, it is up
forward
28th of August, because e-portal,
the order passed by this court on 11th.
yes, e-portal for pensionary papers was locked from the side of the DI. petitioner, the headmaster went to the office. Lock was open. Thereafter, it was through e-portal as well as hard copy also sent by hands. Both way. Now it is pending before the DI for subsequent steps.
Overdrawn amount has been
Paid.
paid.
Paid. You will also recorded that.
What does it say? Which records?
ওটা কবেকার রিপোর্ট দিচ্ছেন টাইম ডেটটা দেখুন স্যার 28 তারিখে রিসিভড it was done.
Come to your report. Second page. Paragraph 3, read it.
However, the school authority did not obtain the files. The school director of account.
So 19th August 2025, it was intimated. When intimated, then file was lying with the school. File sent it was forwarded on 28 August 2025. After that. So is it your report based on this communication dated 19th August 2025? Because school is submitting that on 28 August 2025 it has been forwarded. So on checking the file as forwarded by the school on refixation of pay and after depositing excess drawn amount, whether the position is emanating from this report.
সেটাই আমি বলতে চাইছি
29 August
Try to apply your mind. School is saying by filing a report that on 28 August 2025 they have forwarded the pension file or e-pension file. Now you are the DI is prepared the report based on memo dated 19th August 2025 of the Deputy Director of Account. But situation whether the DI has examined or has gone through the e-pension file of the petitioner which was forwarded by the school authority on 28 August 2025 or not? That is what I am asking. Then I have taken instruction to come back. In terms of the order dated 11th August 2025, the report dated two reports. 11th August 2025. Respondent number 7 has filed a report in the form of affidavit affirmed on 1st September 2025 and same is taken on record. District Inspector of Schools AC Nodia has also filed a report dated 29th August 2025. Same is also taken on record. Next paragraph. However, it is submitted on behalf of the school authority that after taking necessary steps and fixation of and fixing pay and refixing pay of the petitioner. E-pension
paragraph 4 I have stated.
E-pension file was forwarded
through portal, persons who will lordship's order, and email also. An email attachment is there.
Was forwarded through e-pension file was forwarded through portal on 28 August 2025 to the District Inspector of Schools AC Nodia. Stop. Next paragraph. However, on perusal of the district concerned District Inspector of Schools, it appears that based on memo dated 19th August 2025 issued by the Deputy Director of Account, School Education, Nodia, observations are recorded in the said report Stop. Question, next paragraph. Question arises whether report dated 29th August 2025 is based on whether report dated 29th August 2025 is prepared in consideration of e-pension file of the petitioner which was forwarded by the school authority through portal on 28 August 2025 or not. Next paragraph. Learned advocate for the state respondents has prayed for accommodation to obtain instructions. Stop. Hearing of this matter stands urgent. List the matter under the same heading on 16 September 2025. Next paragraph. If District Inspector of Schools AC finds that the report was prepared without considering e-pension file of the petitioner or e-pension file of the petitioner which was forwarded by the school authority on 28 August 2025, District Inspector of Schools within bracket cases shall be at liberty to file a report, liberty to file another report on the next date.
I am not required any further at present.
Yes.
Yes.
Let response comes from
Let this response come.
next.
Report may be kept with the record. Get much obliged.
Item number 9.
Get.
Who is for the petitioner?
For the state only. The petitioner has not come yet. And they have not submitted any report or the supplementary affidavit also.
At the time of call, no one appears for the petitioner and no accommodation is paid for. However, state respondents are represented by learned advocate. Next paragraph. Writ petition stands dismissed for default. Parties to act on the server copy of this order. Next.
My lord,
No, oh,
at the cost of admonition, my lord, may I seek leave to move these?
It's not a mentioning time.
10, my lord,
Till 14th. Mention tomorrow morning.
my lord,
Item number 10, I am for the petitioner.
but in this item number 10, I am for the respondent number 5,
I have
And-
item number 11, I am for the respondent number 8.
I am for the petition.
Item number 10, I have for just a minute. let
দাঁড়াও,
me go
দাঁড়াও।
through my own order.
আগে ও বলে নিক।
এই অমিত There are two petitions, one for giving effect to the transfer. Another is challenging transfer.
My,
Transfer order has been challenged by the existing present school authority where petitioner is working. On what
Lord, the inquiry in respect of,
issue?
well, inquiry is good.
Petition is 18362 of 20.
Yes, yes.
Just a minute, I will
Fine.
hear you. What are the reasons for transfer? On what ground do you apply for transfer?
6 round transfer application. My lord,
Working which post?
I'm a headmaster.
Headmaster.
My lord, school issued, I have applied in the
As per
portal.
headmaster.
My lord, school, my lord, I have applied in the portal, designated portal, school at the ground of distance, general ground. School issued the NOC and transfer application has reached to the commission. DI also forwarded to the commission. Since portal was suspended, that our application was lying in the SSC, School Service Commission, I filed a writ application before your lordship. Your lordship directed the commission consider my transfer application. Your lordship's order is, my lord, 22nd, page 20, 22nd January, 22nd January 2025. It is only
Chairman to take the
take
Then chairman recommended for the transfer.
recommended
Page
transfer.
23.
Yes, page 23.
Transfer
Transfer.
in charge.
Yes. This recommendation has also communicated to the school.
Then order of the transfer by the transfer order by the board, but you are not being released.
Released, my lord, surprisingly, this recommended school issued the NOC. My lord, recommendation has duly communicated.
Which school issued it?
School NOC, my lord, transfer
21.
application 21. My lord, school issued the
Very
NOC.
well, let me hear the school of.
My lord, firstly, my lord, the order was passed by your lordship, my lord. My lord, I have no any knowledge, and my lord, behind my back. Because, my lord, I have inquired in the school, the notice,
Whether any proceeding has been initiated.
my lord, the inquiry is going on. Inquiry is going on. My lord, the
It has been issued.
charge,
Board has received the preliminary inquiry report, my lord, on 28th August.
August.
Board
So
will,
what is the response?
board has decided to issue.
Issue so called.
No, decide, we have just received day before you.
28 August, yes.
Yes, so my lord, the board has decided to issue show cause as per the. If not satisfied with the show, reply of show
Now,
cause.
when this matter was referred to the DI for consideration?
my lord,
My lord, there is a-
DI, my lord, I have informed the DI on 22nd August 2024 that there is an anomaly and yes,
But DI is not received, there is
And-
no receiving copy, my lord. They have annexed the document, there is no receiving.
When stated in your petition, that you have referred the matter to the DI.
My lord, kindly, my lord.
I will hear you. What is that? He, Mr. Ali is answering for the petitioner.
Yes, yes. Received is there. Page, my lord, the first, my lord, I have informed on 21st August, page 14, 1-4.
Oh.
Yes, yes. DI has received. আমি রিসিপ্টটা দেওয়া হয়নি, ওইটা এখানে আছে।
I did not find any receipt. It is, my lord, it is.
রিসিপ্ট কপিটা জেরক্সটা ওঠেনি।
It has reached home.
And my lord, page 43, page 43. Page 43, after receiving this, my lord, the board has issued a letter to the DI to hold an inquiry and file a report.
What are the charges?
Charges is, my lord, the midday meal. My lord, the
But what is the application?
allegation is, my lord, the
Defalcation of
fund,
Yeah,
individual.
My lord,
inquiry was held.
Now you will take transfer and you will be.
my lord, there is, my lord, so cause, my lord, after everything has been planned after my transfer order. There is no whisper that PV before my transfer order, no,
So if you are innocent, face the proceeding.
my lord, I have no problem. I have no problem. What is the difficulty? My lord, BDO has issued 2 show cause notice. My lord, kindly, my lord, I am requesting.
Video is certified.
Yes, yes, I have annexed. I have annexed, my lord, only 50, my lord.
Yes, where is the allegation?
Allegation, my lord, the inquiry was held by the
My lord,
first video, page 35.
Page 35. Page 35, which read petition?
A second, Manwar.
Second,
Second.
page 35. Yes, which is after my.
DI has already conducted an inquiry in the matter.
No, what do you think that after issuance of release orders, if there is misconduct that cannot be against that, no proceeding can be initiated, no steps can be taken?
No, 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 my lord, I am not on that. But my lord, my rule is very clear to that effect. Rule is very clear. My lord, it is everything is, my lord, after my transfer.
Just a
Lordship. First propose, page 30.
There are
Yes, well, irregularities, my lord, I have.
let it be, let the steps be taken by the.
Yes,
board
yes,
in
my lord,
accordance-
in accordance with law,
But
but,
in the meantime, no transfer.
my lord, the provision is there, my lord, subject to correction, my lord. The rule is very clear. My lord, time.
Whatever may be the provision, there will be no transfer. Because you did not come to this court in time. Application was made in 2021. Writ petition was filed on 8 August 2025 after the steps were taken.
Yes.
That shows that your conduct is
No,
not fair.
my lord, after this, my lord,
Yes,
it is not.
what prevented you to approach the authorities for consideration of your transfer just after making application for transfer in 2021? Why this writ petition after 4 years?
4 years, my lord, I am waiting.
In the meantime, much water has flown to river Ganges.
My lord,
That's why
yes.
to avoid this, you file this writ petition. I am very sorry to say this.
My lord,
When
allegation
the
is
application
53.
for transfer was made,
Yes, 2022.
Yes.
2025.
and this writ petition in 8 August 2025.
My lord,
8 August 2025 writ petition. In the meantime, these developments have
my
taken
lord,
place.
52, my lord, I have the explanation.
That doesn't express your bona fide.
My lord, I have
So far,
expressed 50.
pursuing your
My
transfer
lord, 50,
application.
there are allegation 53 heads has been shown excess. My lord, this portal, my lord, midday meal is run by a portal, AMS portal. My lord, AMS portal, if one time data is given, it is not mandatory for correction. Moreover, students generally comes for only taking midday meal after roll call. It is my explanation.
So application was made on 24th January 2022. No,
2020 transfer application or writ petition?
transfer application.
Transfer
21.
application, 21, my lord. Transfer application, I have annex, my lord.
Put-
In my
At that time, portal was open.
Page
Portal,
18 of the writ petition.
page 18.
Yes, my
Which is
Page 18.
22.
18.
First application 21. First application 21. 22.
24th January 2022. 24th January 20, it is pending for a
And
complaint.
unsatisfactory reply. Second so-called also what? Page
Yes, my
37.
lord, I have given
Page
reply.
37.
53, only 53.
He is the
heads.
government officer.
Very well, Miss. What is the file?
Yes, yes.
Report, my lord, we have just received the inquiry report. Now we will issue show cause. And we have to follow rule 5. Issue show cause.
After giving opportunity to a petitioner to respond to the so cause, then you may be satisfied.
If satisfied, then no proceeding. If not satisfied, then charge sheet will be issued. It is as per.
Rule.
So let me adjourn the matter for some time in order to conclude up to the conclude the proceeding up to the court. Instead of giving blanket direction for filing affidavits, I think it may so happen that after considering response to reply of the petitioner to your so called notice, board may be satisfied that it is not a case of initiation of proceedings. So therefore, to that stage, this court should wait and find out what is the outcome after the conclusion of the
চুপ করো, তুমি আবার কথা বলছো।
So within which time you will be able to
So we
conclude,
can issue.
take decision on response to the so called.
But my instruction is we
They
will
must
issue
be
show cause, next 10 days we will issue the show cause. And we generally give a time of 7 days or 15
এমন
days to
ভাবে তো
reply. After receiving the reply, I'll instruct my client to take a decision at the earliest.
So let me explain the matter for 4.
No, more than 4.
Why?
14 to 1
10
month.
days, 10 days, 10
Let
days,
the
then 7 days. Then he will take decisions within 7 days thereafter. So it will take to 10 plus 7 plus 7, 24 days. Under the special, what are the vacations? Vacations or holidays are to be excluded. Board holidays are to be excluded. So I'm saying, I'll direct the matter to come up in the list after vacation. But in the meantime, we take.
Yes, I mean also.
Yes.
It is my duty to assist the court properly because the inquiry. But 20th August, they have forwarded to the board. I have received the inquiry report through my WhatsApp. From the report, there is nothing against the headmaster. About the inquiry finding.
That is the inquiry at page 35 of the petition.
No.
18
By the,
2025.
when board issued the order to the DI to make an inquiry
Which we received. I don't know.
after the order of the board.
It is within the domain of the board.
Yes, yes.
Yes.
Why DI will make submission on this? DI made a preliminary inquiry report forwarded to the board.
Yes.
At this stage, court will not express its mind. So let board conclude conclude the process up to the inquiry stage, up to the show cause stage. So if show cause ultimately, it may so happen that after giving a chance to the petitioner to respond to the show cause notice, board may be satisfied that it is not a case of initiation.
According to law, that is.
By issuing charge sheet.
Yes. According to law, that is not. But from the inquiry report, I have seen that nothing.
It is not your job so far DI is concerned. DI will hold an inquiry, forward it to the board, not to make any expression, not to express its mind with regard to the.
No, that I'm very fast.
The veracity or the nature of charges. That is, the board is the authority to take. You have conducted preliminary inquiry and forwarded it to the board. So therefore, let the board take decision on some.
From the very beginning, I assist the court ballot. What will matter? Midday meal to read.
Are taken up to wait for transfer based on transfer order issued by the West Bengal Board of Secondary Education, by the Secretary West Bengal Board of Secondary Education on 22nd May 2020. Stop. In another writ petition in WPA 18362 of 2025. Who are you?
President of the managing committee.
President of the managing committee of Keserpada High School within bracket HS, Murshidabad. Murshidabad. Hearing after referred to the said school, put a bracket within bracket. Recommendation memo. Dated 7th April 2025, issued by the Secretary in charge, West Bengal Central School Service Commission, and transfer order dated 22nd May 2025, issued by the Secretary of the Board, are questioned on the premise that preliminary steps have been taken by the said school authority as well as concerned district inspector of schools SC Murshidabad for initiating disciplinary proceeding against the petitioner. For initiating disciplinary proceedings against the petitioner in WPA 14663 of 2025, who is the headmaster of said school. Stop. Learned advocate representing the president of the managing committee of the said schools has drawn attention of this court to the allegations against the headmaster stated in memo dated 18 June 2025
And another one, page 37, second Sukaj.
issued by the block development officer, Rani Nagar 1 Development Block, comma, said memo dated 18 June 2025 is in the form of super notice. Stop. Next paragraph, Ms. Vaili Bhattacharya, learned advocate, West Bengal Board of Secondary Education on instruction submits based on information received from the school authority. Preliminary inquiry report was called for from the district inspector of schools SC Murshidabad, and such report when submitted
28.
and such report was and report on conclusion of preliminary inquiry was forwarded to the board on 28 August 2025. Stop. It is also submitted that concerned authority of the board has taken decision to issue show cause notice to the headmaster of the said school, thereby seek response to the show cause notice. Stop. To grant opportunity to the concerned authority of the board to take steps based on preliminary report submitted by the district inspector of schools SC Murshidabad. Hearing of these two petitions stands adjourned for 4 weeks. Stop. List both the petitions under the same name on.
November वाला 2-3 दिन कोर्ट अक्टूबर
28 October 2020. October.
সবাই নাম দিয়ে
Item number 12.
My lord, I beg to appear on behalf of the petitioner in this matter.
Yes. My lord, I have taken instruction, my lord. My lord, when a candidate was recommended in a post, and my lord, sometimes it happened the post, there are certain mismatches, just like in this present case, my lord. Then, my lord, after getting the information from the school or the district inspector of school, commission requested the district inspector of school to find out a suitable vacancy nearer to the recommended vacancy in the same district. And as per the then if when district inspector of school send the vacancy, and after getting the vacancy approved by the commissioner of school education, commission re-recommends the name of the petition.
No, but in this process, no protest is made or no case is made out. Generally, teachers accept or generally candidates accept those re-recommendations.
Yes, ma'am.
But in cases where candidates do not accept re-recommendation without giving further opportunity of counseling, then they give them an opportunity of counseling and offer and disclose the available vacancies which are nearby to the to the school where petitioner was first recommended and obtain his option.
Kindly,
Like in the case of re-recommendation.
re-recommendation.
Like the case of
Kindly,
re-recommendation.
Rule
Those
17
cases which are coming before me,
Yes.
several matters I have disposed of the matter. Directing that the candidate to appear before the chairman, and chairman shall disclose the vacancies, and thereafter, if any vacancies opted by the candidate should be recommended based on some exercise of option. So if that procedure is followed in the present case, what is the difficulty?
That procedure, kindly, if your lordship kindly turns to 17,
So we recommendation.
17(6) of the rules, upper primary rules of 2016, it says that if a candidate whose name has been recommended by the regional commission for appointment, but appointment cannot be cannot be appointed to the vacancy for which he or she was recommended for the reasons that the vacancy ceases to be exist, the managing committee by which name it is called, or by ad hoc committee, or the administrator of the school, district inspector of school, as the case may be, shall send the information in this regard to the regional commission, and regional commission may, on receipt of such information, recommend his or her name to any other appropriate vacancy.
Yes,
So,
appropriate vacancy.
rules also not providing for giving another opportunity to participate in the counseling process.
Says appropriate vacancy, not to any inappropriate vacancy.
A candidate of Bardhaman district was initially, according to her merit position, initially recommended to the district of near to the Raiganj. When re-recommendation letter was issued, recommendation
Be around Raiganj.
Yes, my lord, around Raiganj.
50. But petitioner is saying that it is in the bordering area and far away from the place or the school where petitioner was initially recommended. Now, it is far from the district headquarters also.
58 kilometers.
That's why petitioner is saying for a chance to have a counseling, chance of counseling to exercise option from amongst the available vacancies which is shown to the
That is my prayer in the writ
Direct the
petition.
district inspector of school to find out a suitable vacancy nearer to Raiganj.
That is not a
And
case.
I had a talk with the chair.
Because petitioner appeared in the counseling. In the counseling, petitioner opted the vacancy based on which recommendation was made. Ultimately, it is found that vacancy under the roster point, there is a vacancy mismatch. So the fault is not attributable to the petitioner. It is the fault of the authorities in offering this vacancy to the petitioner, where petitioner cannot be accommodated. So if this is the position, what is the difficulty in giving further chance to the petitioner to appear in the counseling, or at least to disclose the vacancies which are available? And if petitioner opts a vacancy amongst the vacancies which are to be disclosed to the petitioner to be recommended.
It is not the case where petitioner is only candidate, my lord, who is suffering.
Think about the cases of recommendation, my lord, where recommendation petitioner could not join. Where a candidate could not join, then a candidate applied for recommendation. Recommendation application is pending. Court is passing regular order directing the chairman to permit him to appear before him
Then
and disclose the vacancies.
Kindly direct the chairman to conduct a hearing and shows vacancy in the district nearer to Raiganj.
Yes.
In the same district.
I'm not, court will not saying that you offer a vacancy in Bardhaman.
Yes. That is my.
What are the vacancies around the school where petitioner was initially recommended? These will be shown to the petitioner as per merit position.
Then, my lord, kindly, if your lordships kindly pass it over for 1 hour, my lord.
No, I am fixing a date. You file a report disclosing what are the vacancies which are available in the district of Uttar Dinajpur.
Yeah, that's district.
That can be if petitioner opts out any vacancy, petitioner can be
disposed of also.
Yes, my lord.
Direct
Kindly
the
fix the
commission.
date, my lord. I shall.
No, I'm telling you, lordship.
Because
Lordship,
I
direct
have
the
to make
commission
up-
to show me the options. I choose. If I find suitable, I will take it and I'll go. No problem.
My lord, kindly direct.
Can be disposed of.
appear before the commission.
My lord,
Yes,
kindly
it will be
direct me to
disposed.
file appropriate instruction, my lord.
Yes, it can be disposed of.
Because of the fact, my lord,
Similar procedure is to be followed as in the case of recommendation.
my lord, in the
prayer is
recommendation process portal, in the portal vacancies are available. In this case, my lord, we are not the vacancy generating authority.
They have the
My lord, the vacancy generates by the district inspector of school, my lord, through commissioner of school education board.
No, I want
and
from
board.
the available
My
vacancies.
lord, now, my lord, in after
Same.
kindly,
To generate.
my lord, in after 2018, my lord, the roster maintaining authority is the board. So, my lord, school service commission is not the vacancy generating authority. My lord, school authority sends the
But in
vacancy to
case
the.
of recommendation,
It is in the portal. It is in the portal.
but portal is suspended.
My lord, it is portal is suspended, but my lord, we can, my lord.
I have passed at least 20 orders in
My matters.
recommendation after suspension of portal.
Yes, my lord.
So how you
We-
get the
Commission has access in the portal, but my lord, not to recommend any candidate by using the portal. In case of Uchchasri. But in the present case, my vacancies are notified.
May I just say one?
Let me direct that the DI shall forward the vacancies.
Yes, my lord.
DI shall intimate the vacancies to the chairman. Available vacancies in the district of it is in Uttar
Dinajpur. Yes.
Within certain time.
Yes, sir.
And based on which petitioner shall be granted an opportunity to opt for a vacancy which will be disclosed to the petitioner, but it will be the exercise will be confined in the to the district of Uttar Dinajpur, not beyond.
And this order is
Yes.
in exceptional circumstances, my lord. This order.
Well, one thing, my prayer is that it Dinajpur only. I never said keep it near my house. I never said Dinajpur near the school.
That I remember, the bordering area far away from the district headquarters. That's why petitioner is praying that grant me an opportunity to appear before the authority in order to find to opt for a suitable vacancy.
Whatever vacancy is available, I am not saying create vacancy for. So,
You are appearing for DI. So let the DI forward available vacancies to the commission, chairman of the commission by fortnight, and thereafter within 30 days, the chairman shall complete the process. Matter is hard in presence of the knowledge that advocates representing the petitioner on West Bengal Central School Service Commission and district institute of schools and technical, district state respondents, and West Bengal Board of Studies. Next paragraph. Petitioner on being selected in first state level selection test 2016 within bracket upper primary was recommended with a memo dated 17 December 2024 to Mohanbati Parvati Devi Balika Vidyalaya, Uttar Dinajpur. Within bracket, hereinafter referred to said school. Close bracket. Stop. Petitioner attempted to join the recommended post, but said school authority did not allow the petitioner to join since it was found there is vacancy mismatch.
বলছে রায়গঞ্জের পাশে কোনো একটা স্কুলে দিতে বাংলাদেশের পাশে যে কোনো সময় বলছে ইয়ে করে দেবো হাসি দেবে
Those are 0.45 vacancy, that is not 10. Several other matters, the court is finding.
সেটা কে করবে আমি কি করে করবো
Several categories of matter. When Mr. Rai, Ujjwal Rai is moving several matters, where it's a case of vacancy mismatch. Then first recommendation was made in November 2024. That could not be given effect. Subsequent recommendation in January 2025. Now he is saying that in terms of 2019 ROPA rules, 6 months, if he would have been appointed in December or prior to 1st of January 2024, in that event, his first date of increment would be on 1st of July 2025, but he is missing that date of increment.
Prior to joining, fighting for increment.
Why they are doing this? They can come with the team list. No roster is
In those cases, candidate accepted this recommendation, but praying for that his appointment should be treated from the.
I confirm that.
Yes.
I also made
The next in the next round of it.
Next round.
Hey, Lordship, can hold the prayer. Any other prayer?
There is vacancy mismatch. Stop. Subsequently, petitioner was recommended with a memo dated 23rd May 2025 to Takulia High School. However, petitioner is not willing to join the post in Takulia High School, as it is submitted that Takulia High School situates far away from the district headquarters in Uttar Dinajpur. Takulia High School situates far away from district headquarters at Raiganj, district headquarters at Raiganj, Uttar Dinajpur, and it situates at bordering area. So, there is another means of submission advanced on behalf of the petitioner. That is, in the event petitioner is recommended again. That is, prior, no, that is bucket academy. That is prior to issuance of second recommendation memo dated 23rd May 2025. Petitioner is required to grant an opportunity of counseling based on available vacancies in Uttar Dinajpur. Next slide. Learned advocate representing West Bengal Central School Service Commission has opposed the prayer made on behalf of the petitioner, or has opposed the writ petition, based on
17.6.
Rule 17 within bracket 6 of the West Bengal School Service Commission within bracket selection for appointment to the posts of teachers for upper primary level of schools close bracket rules 2016. So, it is also submitted as per merit position in the select list. Petitioner was recommended in a school in Uttar Dinajpur. Therefore, by taking advantage of present situation, petitioner may not be recommended to a school which is nearby to our place of residence. Next one. It is also submitted on behalf of the commission that in case of available vacancies in a school in Uttar Dinajpur where petitioner can be accommodated need to be furnished by the concerned district inspector of schools AC Uttar Dinajpur. Otherwise, chairman of the commission at present may not be able to disclose all the vacancies. For appointment of petitioner. Next slide. Having considered the submissions made on behalf of the parties, District Inspector of Schools, AC, Uttar Dinajpur, have you made DI party? No. District Inspector of Schools, AC, Uttar Dinajpur, is directed to forward vacancy statement to the Chairman West Bengal Central School Service Commission with instruction by fortnight from the date of communication of this order, disclosing available vacancies where petitioner can be accommodated in Uttar Dinajpur. Stop. On receipt of vacancy statement from the concerned District Inspector of Schools AC, respondent number 4 shall permit the petitioner to appear before him, and available vacancies in Uttar Dinajpur shall be disclosed to the petitioner for issuing fresh recommendation. Stop. In the event petitioner opts a vacancy. Comma. Fresh recommendation shall be issued in favor of the petitioner. So, aforesaid exercise shall be completed by the respondent by 4 weeks from the date of receiving vacancy statement from the by 4 weeks by 4 weeks from the date of receiving vacancy statement from the district inspector of schools AC. Next, leave is granted to the petitioner to amend the first title in case of this bill, or leave is granted to the land advocate to amend the first title in case of this bill and add district inspector of schools AC as additional. Stop. However, service of notice upon election of respondent stands dispensed with, since respondents are represented, still should state respondents are represented. Why not? Next paragraph, writ petition stands disposed of. All over we can see in the state of in the district. No, that will be confined to the vacancies in the district of Uttar. That I have clarified.
Amendment item number 13.
Nearby vacancies, also faraway vacancies, all vacancies, present vacancies which are available in Uttar Dinajpur, that has to be disclosed. Absolutely. It may so happen that nearby vacancies are not available. So that's why whatever vacancies which are lying in the district of Uttar Dinajpur to be
There are two types of vacancy. Vacancy lying with the commission, vacancy with the DI. There are different vacancies.
So DI will forward it and the
Commission already has its
chairman
rule
will
of
disclose. Next.
For the state matter.
Recommended by the school when his recommendation was Section of time to join the 11 November 2024 was the recommendation. Upper primary. First specialist upper primary.
Yes, ma'am.
Then petitioner could not join. There what happened? When application was
Page 24.
24.
Yes, ma'am.
23, my lord.
23, 24, please.
That is within 90 days.
My lord, extended for 1 month. Now, my lord, after expiry of that time, petitioner again made an application for further extension of 3 or 4 months.
Because my legal condition is such manner that I could not join before.
Page 26.
Page 7, paragraph 11. Empire transfer procedure. We are working in another school. Yes, service. So why you are paying for appointment in? Because since you are working in another school, that is in Purva Validity. And recommended school is also included. Now, since you are working, why it is necessary? Because you are working in the in upper primary section. No, no. So, I could understand if you are an unemployed candidate. If you are not an unemployed candidate, you are working in a school. Why it is not a case of transfer? You have not applied for transfer, so it's a fresh appointment. So why fresh appointment was? Why petitioner participated in the selection process for fresh appointment? Because I could understand that on acquiring higher qualification, if suppose petitioner is working against a post which is meant for postgraduate candidate. Now subsequently petitioner obtained postgraduate qualification and offered candidature for class 9, 10 or 11. I could understand. But this appointment, this recommendation shows that you are appointed for upper primary level of classes. So how it will improve your situation, your condition of service?
Well, after first time of recommendation, as per the prayer of the petitioner, School Service Commission extended for 1 month.
27 February 2025.
Yes, my lord, for 1 month.
25.
That
Why it was
extension,
addressed to the, it is addressed to the present school of the petitioner.
yes, sir. Malad, therefore, Malad, this extension expire on 29th of March 2025. 1 month.
Is to be counted from which date?
From the date of issuance of this,
That's to
receipt of this letter. मिले बाटी दी.
So why the extent, during the extension, extender did not join? I don't. Then what can be done?
Then now, my
How
lord,
long the authorities will wait, and then another candidate's right could be deprived of, could be deprived. But there is no provision as such. There is no provision as such. At best, 90 days and then 60 days.
150 days.
And that is over. 11 November 2024, December, January, February, then March, April. It's over. And
Now-
during this period, already there was an extension of 1 month.
And again, my lord, after expiry of that period, my lord, now presently applied, my lord. Within that period, my lord, petitioner has not made application, my lord. And it is not, no receipt is there, my lord. Whether this application is at all before the commission or not, my lord, that is also. Page 26.
Affidavit service filed on behalf of the state. On being selected in first state level selection test 16. Petitioner was recommended. It is remote dated 11 November 4. To Bishopur, Avadaran, Manipur, HS. Petitioner instead of joining the post. Made application for extension of validity of recommendation. Dated 11 November 2024. On 18 January 2025. based on application for extension of validity of recommendation. Concerned authority of West Bengal Central School Service Commission for short commission by issuing memo dated 27 February 2005, extended validity of recommendation for 30 days. However, petitioner could not join within the extended period of recommendation and has filed the present petition seeking extension of validity of recommendation for longer period in order to facilitate her joining in the recommended school as per memo dated 11th November 2020. Next paragraph, learned advocate representing the commission has prayed for and advocate representing the commission has submitted in spite of extending validity of recommendation between 27 February 2025, petitioner failed to join the recommended group. Therefore, there is no further scope left open to extend validity of recommendation, and same is not permissible under Rule 17 within bracket 4 3 Rule 17(3) of the West Bengal School Service Commission within bracket selection for appointment to the post of teachers for upper primary level of schools. Close bracket rules 2016. Next paragraph. On consideration of application seeking recommendation of on consideration of application seeking extension of validity of recommendation, it appears that petitioner was undergoing IVF treatment, as a result whereof she could not join the recommended post as per memo dated 11th November 2024 within the prescribed period. Stop. However, petitioner applied for extension of validity of recommendation, which was allowed by the concerned authority of the commission with a memo dated 27 February 2025, thereby extending the validity period of the recommendation for 30 days. Petitioner could not join. No, 30 days, stop. Even after extending the validity period of the petitioner does not join the recommended. Next one. In terms of Rule 17 within bracket 3 of the state rules of 2016. Once recommendation is issued, same shall remain valid for 90 days, and concerned authority of commission may, if it thinks expedient, is authorized to extend the validity of recommendation beyond the period of 90 days for any reasonable cause. And the reasons to be for any reasonable cause, comma, and the category, reasonable cause, comma. Such reasons to be recorded in writing in order to extend the period of validity of recommendation letter for a further period not exceeding 60 days. Next slide. Therefore, in terms of Rule 17(3), it appears for a maximum period of 150 days, recommendation issued by the commission can remain alive, provided validity of recommendation is extended for a period of 60 days beyond 90 days. Stop. In the present case, at my hand, recommendation was issued on 11th November 2024. And on 10th April 2025, (150) days expired. Moreover, now expired, stop. During this period of 150 days, petitioner's application for extension of duty communication was accepted by the concerned, accepted by the commission.
Extension of recommendation.
Or extension of recommendation. Extension of recommendation was accepted by the commission, and 30 days recommend and recommendation was extended for a further period of 30 days in terms of Rule 17. But petitioner did not join the recommendation. In view of efforts in aforesaid conspectus, no relief can be granted to the petitioner.
Rule 17(3), probably my lord rule. Your lordship says that Rule 17(4).
No,
Last.
Item number 175 from monthly list.
An advocate representing the commissioner submits. Still has to be. State respondents are represented by the hearing of this matter stands adjourned. Release the matter under the same heading, March 6th of December. Next.
Item number 176.
Yes, one after another. At the same order for the state respondents are not.
Same order state.
Then what is the correction? Next.
Item number 177. একবারও না
Yeah, for the state, state respondents represented same order.
Item number 178.
Which for the state,
I'm for the state.
state respondent is represented same order.
Item number 179.
Which for the state. One. State is not represented, the we put that sentence.
Item number 180.
The last occasion.
Where is the report?
না পাওয়া যায় তো দেখ আমি একবার সিএফ কেস 2258
Yes.
Yes. Year 2020.
No, present matter. How in 2020? DI says before expiry of the term of the existing management.
कैसे था
To charge on 1st April 2020.
Functional base 7 and they are not taking over
আমাদের এই
and they have issued a nomination of 19 April, page 8. Functional school education requested the DI for taking over the valid tenure of 3 years. First memo was issued in the year 2020 and statutory paragraph 3. The new functional school education instruction 12 March to the director of school education appointed the petitioner as nominated PI members of the managing committee under the supervision of high school. But they are not taken over church. They have made a representation.
But this is a memo dated 5th December 2020. Which is under challenge.
Yes, and they are
I could not follow your submission.
under commissioner of school education.
Yes.
12 March 2020 nominated nominated the PI members of the present.
There are two person interested in education under the category of PIE. There are two members on the managing committee. Now, when they were appointed in 2020, where is the appointment letter? Where is the memo by which petitioners were inducted? Yes.
They have issued on 19 April 2023, page 18. commissioner creating the DI. Thereafter,
19th April 2023, where from you are submitting that they were appointed in 2019. Where it is April 2020.
page I am sitting in paragraph.
Page 17.
Yes. Remunerated 12 months.
This Koruna Maji and Ranjit Mahato, they are the petitioners. Now though they were inducted as person interested in education, but they could not function as person interested in education prior to first of April 2023.
They have taken out the landing for the field. And there is a tenure of 3 years, and without cancelling their nomination, if you private fund over the appointed page 20. Column number 2. And counts 1.
So is it your case that you are functioning as both of you are functioning as person interested in education on the managing committee from the month of April 2023?
Yes, sir.
Not prior to that.
No.
Now this tenure will end April 2024, 25, 26.
And
In 26. In 26.
Yes.
Now, in the midst, these two persons have been permitted, have been appointed as person interested in education. So at best, they can be inducted as under the category of person interested in education on the managing committee of the school after expiry of the present tenure.
And earlier, my lord president was repeat the geological similar order.
That I didn't.
And will noted that take note of the
For correction.
because by the definition of
Just a minute.
देखिए order देखिए
हाँ order.
पार्टी का तो शिवा ने सोम वगैरह की पार्टी
But in this order, it is stated that the president took charge on 21st March 2023.
Yes.
Whereas DI is saying that took charge on 1st of April 2023. It's not telling.
The tenure has not been completed 3 years.
I am on the date of commencement of the tenure of the managing committee. From which date it started?
It starts from 19th April. They have taken over charge, my lord.
No. I have stated in my order 21st March 2023. DI is saying 1st of April 2023.
In respect of president. They are the PI
So if president is there in the managing committee, then PI will be also there in the managing committee from the same date. From the date when the charge was taken over by the existing managing committee.
Yes, my commissioner is to
Tell me from which date charge was taken over.
page 17, 24 April 2020. As per memo dated 19 April, I think were nominated. Page of announcement and page 9.
Page
19 and page 2.
issue.
in terms of previous order, the report is filed by the District Inspector of Schools, SC Purulia, being respondent number 6, dated 3rd April 2025, and same is taken on record.
ফিফথ মে থেকে ডিসমিস হয়েছিল এই মামলাটা?
না
ও রেজিস্টার করেছেন? কিন্তু আমি জানি না। ওরাল ওরাল রেজিস্টার করেছেন? অ্যাপ্লিকেশন করেছেন?
Next paragraph, on perusal of the report, it appears both the petitioners were inducted as persons interested in education, within bracket TIE, close bracket, on the managing committee of Katadihi Shiksha Shatra High School, within bracket HS, close bracket, Purulia, within bracket hereinafter referred to as said school quote unquote, close bracket. With a letter dated 24th April 2023. Stop. It also appears from the said report present managing committee took over charge. The present managing committee of the said school took charge on 1st April 2023. And petitioners were permitted to function as members of the managing committee under PIE category on and from 24th April 2023. Next paragraph. As per impugned, you have challenged this 5th December 2023. As per impugned order dated 5th December 2023, issued by the Deputy Director of School Education within bracket basic, close bracket West Bengal. December 2023, West Bengal. Two different persons or two other persons were nominated under PIE category on the managing committee of the said school. Stop. However, two newly inducted persons as per order dated 5th December 2023 could not function as persons in as PIE since petitioners under the same category are functioning being the members of the managing committee. Next paragraph. In terms of Rule 10 of the Management of Sponsored Institutions within bracket secondary close bracket rules, 1972, term of the managing committee is 3 years, and in the present case since managing committee took charge on 1st April 2023, tenure of the committee shall not expire prior to, or tenure of the managing committee will expire on 31st March 2026, comma, not prior to that. Therefore, petitioners at present since are functioning as members of the managing committee under PIE category. Impugned order dated 5th December 2023 ought not to be given effect to. It appears without considering the fact that petitioners were permitted to function as members of the managing committee under PIE category with effect from 24th April 2023 24th April 2023 by issuing order dated 5th December 2023. Two other persons have been inducted. Two other persons were inducted as members of the managing committee under PIE category. Next paragraph. Reliance is placed on the order passed by this court dated 17th March 2025 on a writ petition being WPA 27363 of 2023. In similar situation, in the same school, in connection with nomination for functioning as president of the managing committee. Stop. Copy of the order dated 17th March 2025 is retained with the record. Next paragraph. Hence, order dated 5th December 20, hence order dated 5th December 2023 issued by the Deputy Director of School Education within bracket basic close bracket West Bengal is set aside. Stop. In the event managing committee, in the event term of the managing committee in the event term of the managing committee, in the event present managing committee of the said school, in the event present managing committee of the said school remains valid till 31st March 2026, petitioners shall be permitted to function as members of the said managing committee under PIE category, provided petitioners are not disqualified otherwise. Stop. After expiry of the term of the present managing committee, concerned state authorities shall be at liberty to nominate other persons to function as members of the newly constituted managing committee under PIE category by passing appropriate order. Next time. Writ petition stands disposed of, urgent xerox certificate. Next.
Item number 181.
Who is for the respondents? Yes, what is the matter?
Report or the direction for filing report by the commissioner. Here is the report.
Yes. Yes.
Father was in receipt of pension. Yes, I am asking you. You are the daughter of the deceased teacher. You do not know whether your father was getting pension or not.
Proceed. My father has already get the pension.
Yes.
My father was already get the pension after his return.
So father was getting pension.
Yes.
Father died. Thereafter, you are seeking family pension.
Yes.
But service book, if father was granted pension, then where is the question of submission of service book? Mr. Dey,
My lord,
where is the question of submission of service book?
that part, my
Father
lord,
was getting pension.
I could not ascertain, but page 16 of the writ application, this is the PPO of in the name of father.
So father was in receipt of
Yes,
pension.
in receipt,
It
but
goes to show.
yes, but subsequently that service book got not found to be not available, but the department.
For that, petitioner should not be penalized.
No, that is the why, my
not
lord.
Granting family pension.
No, that is why, my lord. Last but the third page, the departments, the interdepartmental communications, my lord. That last but the third page come from commissioner to the secretary of the education for dispensing with this for relaxation of this unavailability of the
Which
subject.
page?
Last from my report, my lord. Last but the third, my lord, dated 21st July 2025. DI has sent a formal proposal. Thereafter, commissioner has sent to the department, which will be the ultimate authority. It will be sent to the finance department.
From commissioner to the secretary.
Is prayed for in terms of geo. My lord, last paragraph. There is a provision to dispense with the submission of service book if finance department permits in order to settle the prayer for family pension. Therefore, in terms of the said provision, I would like to forward herewith all the relevant papers to you for your kind perusal and taking onward action to obtain the permission of finance department.
So this was sent not far back on 18 July, 21st July 2025. What is the present position?
Present position, my lord, that
So it
finance.
was sent to the secretary. How long it will be kept pending before the secretary? Another 10 years.
No, not 10 years, but since, my lord, up to this level, my lord, they have tried, my lord. I'm on a seeking further time, my lord, I shall.
So let me direct the state authorities to settle the pension case of the petitioner by dispensing with the requirement of submitting
It's
service.
finance department should also be, my lord.
Finance department is sitting idle. What can be done?
No, after, my lord, a secretary.
Already July 2025, August, already more than 1 month has passed. 1.5 months. Nothing has been done.
No, chronological events are there, my lord, that from DI to secretary, they are working on this, my lord, and if your lordship pleases, so, my lord, since no one has objected to the same, but after all, if we are waiting from the decision of the finance department, they have to pursue, or if my lord directs, that shall be abided by.
Now, since the commissioner is writing to the secretary, school
Yes,
education department,
yes.
that there
To
is
seek
in
the
terms of the
concurrence
provision
of the
number so
finance
and so,
department.
provision of geo number so and so. Issue. Let it be disposed of.
Unmarried daughter? Unmarried daughter? So have you submitted legal age certificate and income certificate? Kushun, sir. Those are the relevant documents.
No.
Yes.
No, legal error.
That will not do. That will not do. Then even if it is dispensed with, you are not in a position to, due to want of relevant documents, you will not get pension. It has to be by the district magistrate and district delegate that this legal age certificate, and appropriate authority is required to issue income certificate. These are the relevant documents.
Yeah.
Only for legal age
Legal
certificate
age-
issued by the collector. And income certificate is also required because if the income is below the particular limit,
Yes.
and now it is 8,000 or 9,000 perhaps, then the candidate is not entitled to get, the applicant is not entitled to get family pension. Where are those documents? Why in that if all the papers are not ready, why unnecessarily court will direct to dispense with when no formal decision is taken by the finance department? In other aspects, your application for family pension has to be made ready. Then court can direct the authorities to dispense with requirement of submitting service book in terms of the relevant government order as dated 13th April 2010. But if your application is not ready, then why court will grant further time to the state respondents to come back with a further response?
Yes, only in that case, may I just let them authority decide within a time frame manner, but subject to production of those relevant documents as required, as may be required, that may be in disposed of. From the date of his production of those documents, authority will finalize the issue within a time frame manner.
Issue. A report is filed by the Commissioner of School Education, West Bengal, dated 22nd July 2025, and same is taken on record. Next paragraph, on perusal of report it appears. Vide memo dated 21st July, next paragraph, on perusal of report it appears. Vide memo dated 21st July 2025. Commissioner has forwarded the issue, Commissioner has requested Secretary School Education Department, Government of West Bengal, for dispensation of requirement to submit service book in terms of GO number 96 hyphen capital S capital E within bracket capital B close bracket dated 13th April 2010 for settling pension case of the for settling family pension case of the petitioner, who is unmarried daughter of a deceased teacher. Stop. It further appears that in spite of forwarding the issue to the Secretary School Education Department, vide memo dated 21st July 2025, Subsequently, no clarification has been, clarification has been forwarded to the Commissioner of School Education, West Bengal, permitting the authorities to settle the family pension case of the petitioner by dispensing with requirement of submitting service book. Stop. Next paragraph. As Commissioner of School Education has said in memo dated 21st July 2025, in terms of GO number 96-AC within bracket B, dated 13th April 2010, dispensation of submitting service book is permissible, and till date no response comes from Secretary School Education Department, comma, Commissioner of School Education as well as concerned DI is party.
DI is party. Respondent number 5.
Commissioner is not party. Director of School Education is party.
Last of
That is respondent number.
Commissioner of School Education and District Inspector of Schools AC Bankura, being respondent numbers 8 and 5 respectively, are directed to settle family pension case of the petitioner by 8 weeks from the date of communication of this order. In the event petitioner submits relevant documents, or in the events petitioner submits requisite documents for releasing family pension. Stop. Petitioner shall be at leave, or petitioner shall be at liberty. Petitioner shall be at liberty to submit requisite documents for settling her family pension case before the respondent number 5 by 4 weeks from date, if those are not submitted till date, in order to facilitate state respondents to release family pension. Stop. Now, in order to release family pension, since petitioner is unmarried daughter of a deceased teacher who retired on 31st December 1994 and died on 24th October 2011, comma, mother of the petitioner predeceased father. Next paragraph. Writ petition stands disposed of by the
8 weeks from the date of communication. By that time, it's my
4 weeks he will submit.
Whether it will be possible for him to collect this document within 4 weeks, or better, if my lord is subject to correction, from date of 8 weeks from the date of his submission of those documents, if your lordship wishes.
If he submits document after 10 years, if she submits document, what will happen?
Otherwise, in absence of those documents, also authority.
Next matter.
Item number 182.
There are difficulties.
Yes. Yeah.
When you are Mr. Day, when you are approaching this court for family pension, it is presumed that you are coming being an eligible candidate. The documents are required to be served within certain time. Documents are required to be submitted within certain time, or after submitting documents, you are coming. Yes.
They have also facilitated to some extent.
Yes. This is not a similar case. I remember this case. It's a difficult
After
case.
the order,
All matters cannot be brought under the same umbrella. Yes. Yes.
Get all the documents to the DI office and my instructions are that it has been simple. After that, I have to ask the instructions.
That's true. Yes. Suitable. Yes. Whether the income certificate and unmarried
yes, my
certificate
lord, after
have been furnished before the DI.
my lord,
Yes.
after production of requisite documents, the DI, my lord, prepared pension file and sent to the, my lord, Director of Pension on 26th August 2025 for approval. For approval. Last page.
August it was sent.
Yes, last, my lord, annexure.
So now you are also representing the Director of Pension. So when it will be released in favor of the petitioner?
Not
because petitioner was in receipt of family pension.
Yes.
Prior to attaining age of
Yes.
25 years.
Two documents, my lord, were required that was subsequently obtained from the, my lord, collector office and submitted it. My lord, accordingly, my lord, DI forwarded it. I think, my lord,
Yes, but you are not representing DI only. You are
yes,
also
I am representing also the
yes.
Director of Pension, my lord. My lord, kindly fix it, my lord, after vacation. In the meantime, my lord, because in the meantime, my lord, the Director of Pension will, my lord, take appropriate steps for issuance.
On the monthly list, it will be taken up after fortnight.
Fortnight.
In the meantime, you take steps. Otherwise, court will direct the authorities to release the pension. Because I have heard this matter on number of occasions.
Your lordship knows, Malad, there was some Malad, it is the unique case.
Today we need not enter into those issues.
Those two documents were not
those
submitted.
issues. Now, petitioner was in receipt of family pension. Petitioner attained 25 years of age. So therefore, after attaining 25 years of age, whether petitioner is to be granted family pension or not.
Yes.
It hinges on the issue whether petitioner has been able to submit income certificate and no marriage certificate.
Yes.
So those documents have already been furnished. DI has forwarded to the DPPG. DPPG will take steps for release of pension, family pension in favor of the petitioner.
Yes, my lord.
Fortnight, take steps.
My lord, before vacation, any date, my lord, because I think, my lord, within that time, my lord, the pension payment order will be issued. Instead of, my lord, before vacation.
Yes.
I think they will get, EC will get it.
No other issue?
So pension is in pending. From after filing this case, the pension they started, but prior to filing the case, from 2000 to filing the case, the arrears of pension they have not paid. That is different.
From what
Area
area?
from which date?
And from the date when the mother died, I mean the petitioner's mother died in the year 2000, and from that day till the filing of the case, they have not paid.
No, my lord, because after mother's died, father was there. Though they are, my lord, they are disputing, it is my father. Though, my lord, during their, my lord, wedlock, father's family is there.
So you are seeking area from the date of your birth.
From the date of
From which date you are receiving family pension?
after filing of this case, for 7 months we received. For 7 months we received.
But, my lord, prayer is only different, my lord, compassionate appointment only. Only, my lord, kindly come to the, my lord, prayer, page 34. Terminal benefit including, my lord.
Viral, in any event, issue read Bosho. Read petition cannot be decided in the motion stage.
Yes.
So I remember that while I was hearing at the first occasion, on the first occasion, then I found that at this stage only the direction can be given for commencement of family pension
Yes.
beyond 25 years of age.
Yes, my lord.
So let me direct the authorities to release petition, family pension in favor of the petitioner based on documents which have been forwarded by the DI to the director.
My lord.
And let there be exchange of affidavits with regard to claim of arrear pension, arrear family pension.
দেখেছি কি ছেড়ে গেছে দেখেছি না দেখে বলিনি টার্মিনাল বেনিফিট
Issue. Client advocate representing the state respondents has filed one memo dated 2nd September 2025 put by the District Inspector of Schools AC close bracket North 24 Parganas relating to processing family pension case of the petitioner. And same is taken on record. Stop. It is submitted. Next paragraph. It is submitted on behalf of the state respondents that income certificate and unmarried certificate were submitted by the petitioner before the District Inspector of Schools AC North 24 Parganas Barasat, being respondent number 5, and thereafter family pension case has been forwarded, or family pension case was forwarded with a memo dated 26th August 2025 to the Director of Pension, Provident Fund and Group Insurance. Next one. It needs to be recorded herein that prayer of the petition, prayer of the petitioner is twofold, comma, resumption of, commencement of family pension after petitioner attained 25 years of age and release of ADR pension. Release of ADR family pension. Stop. Next issue relating to release of ADR pension needs to be decided on exchange of affidavits. Stop. Let affidavit in opposition to this writ petition be filed by 1 week after ensuing puja vacation, and affidavit in reply thereto, if any, be filed by 2 weeks thereafter. Next paragraph, petitioner shall be at liberty to mention the matter before the appropriate bench for hearing after the time fixed herein above for exchanging affidavits. All parties are present. School? No, there is no school. All are the state respondents. Stop. Next paragraph. It is found that respondent number 5, after submission of necessary documents by the petitioner, forwarded the family pension case vide memo dated 26th August 2025 to the Director of Pension, Provident Fund and Group Insurance. Director of Pension is also not party. How you draft the writ petition? The pension case, family pension case, Director of Family Pension, Director DPPG is not made party. What steps order court can pass? Court no. I am not seeking any suggestion from you. Why you have not added DPPG as party? What direction court will grant upon a authority which is not party and no instruction is obtained by the learned advocate from the DPPG? Everything can be handled in casual fashion. কি বলছিলাম? West Bengal. Director of Pension, Provident Fund and Group Insurance, West Bengal is directed to release family pension in favor of the petitioner based on documents forwarded by the respondent number 5 by 4 weeks from the date of communication of this order. Stop. Next paragraph. Leave is granted to the learned advocate for the petitioner to amend the cause title and array District Inspector Schools, the Director of Pension Provident Fund and Group Insurance, West Bengal, as additional respondent in course of this day. Stop. However, service of notice upon the additional respondent stands dispensed with, since state respondents are represented by learned advocate.
Hold on. Item number 183.
At the time of call, no one at the time of call, no one appears for the petitioner and no accommodation is paid for. Stop. Next paragraph. State respondents are represented by learned advocates or respond. You are for the board. Respondents are represented by learned advocates. Next paragraph. Same situation prevailed on 17 July 2025. Next paragraph. It appears petitioner has lost interest. Stop. Petition stands dismissed for default urgent xerox. Now, dismiss for default. Next paragraph. Parties to act on the server copy of this order be downloaded from the official website of this court. Next.
Item number 184.
Body law.
Page 26.
Yes, page 26. '84 examination was held in 1984, and you have filed the writ petition in 2024. You are very prompt. This certificate of Madhyamik Pariksha was not available to the petitioner.
Applied for correction before the board in prescribed format in 22. 84 Madhyamik passed, in 22 made an application before the board.
What correction you require?
Page 19.
No, page 26, what correction is it?
That's why I was showing you page 19.
No, first tell me from page 26, what correction?
So the date of birth will be 21st of February 1970.
70 না তুমি 66 চাইছো আর তুমি 99 চাইছো সেভেন্টি চাইছো আর বোর্ডের রেকর্ডে
22nd February 1966. It is written 1960, 22nd February 1966. You want 22nd February 1970.
Page 90. Page 90.
Page
90. 190.
my lord, see when the birth
I will hear
certificate is
you.
issued.
I will hear you.
Page 19, my lord, my learned friend is showing.
Page 19. Just a minute. Let me reach page 19. I am trying to read.
The data on the left hand side here.
When this was issued?
1999.
Yes.
Duplicate.
When your birth certificate was issued, Mr. Bhattacharya? After 20 years. After 20 years.
So the handy comes to be at page
A
20.
person who was born
No, this is where I have documents to that.
In 70, his birth certificate is to be issued in 1999.
And it comes to page 20, and it comes to page 20.
It is not.
Certificate and this is the second paragraph. She left the school of.
Now, any application was made
Well,
for,
that is also
any application is made.
an application in prescribed pro forma is made.
Page 27. And they have acted upon. And this is
22.
Have you taken any decision? Have you taken any decision?
No, it cannot be changed. First of all, within 5 years
Take decision.
joining of service. Otherwise,
Whatever maybe you take decision, why you are not taking decision? When this application was made for correction of
22.
documents relating to petitioner's participation in Madhyamik examination,
12th May 2022.
which page?
Page 27 and it's your P6. This is the application not made by me, the headmaster of the school. Then we got kindly comes to we got page 29.
When this application was made?
12th May 2022 at the bottom. Then we got
Why till date decision has not been?
my lord, what? My lord, I'll show. My lord, come to page 30. This is
No, there may be a very bad application.
No, we have asked the concerned school. My lord, that is the reason I am trying to show your lordship the form, pro forma. My lord, that is at page. What the page?
Application may not have merit, but you have to decide it.
No. It is incomplete. That is the reason we have asked the concerned school. Because my lord, my last column, my lord, the head of the institution is required to explain how the mistake occurred.
Page
27.
27. My lord, page 20. This is the application he made. The last column, your lordship 4.
You ask the headmaster as well as the petitioner to appear before.
We ask the headmaster of
authority of the board
Yes,
and take decision if
but
there is
this-
no appropriate clarification regarding the prayer made for correction of date of birth as stated in the certificate. You pass an appropriate order.
Well, we have asked the headmaster of the school, your lordship. That is at page, page 30. Well, the concern.
No, that's not the. That is similar to page 30.
Yes, that column is blank. That portion of the application is blank. But have you ever asked the parties to appear before the board? Then
a hearing may be given.
who is the appropriate authority?
Well, the secretary.
Secretary of the board.
No, deputy secretary records.
No, he will not give the hearing. Hearing either secretary or president. As your lordship pleases.
So, affidavit of service. Yes. Petitioner prays for correction of his date of birth as stated in the certificate issued by the concerned authority of West Bengal Board of Secondary Education relating to petitioner's participation in Madhyamik examination or Madhyamik Pariksha karo. Madhyamik Pariksha within bracket secondary examination close bracket held in 1984. Learned advocate representing the petitioner submits inadvertently it is stated in the certificate of Madhyamik Pariksha 1984. Date of birth of the petitioner is 22nd February 1970 instead of 22nd February 1966. Stop. An application in the prescribed format was made by the petitioner, was made by the headmaster of the school, where petitioner studied up to class 10 before appearing in Madhyamik Pariksha 1984 on 12th May 2022. but till date, the same is not decided. Next paragraph next paragraph, West Bengal Board of Secondary Education is represented by learned advocate who submits based on where is your birth certificate? Yes, based on birth certificate dated 20 December 1999. Based on birth certificate dated 20 December 1999. It is difficult for the concerned authority of the board to take decisions, taking note of the fact that petitioner was born on either on 22nd was born on 22nd February 1966 as recorded in the relevant certificate. Next paragraph. Having considered the respective submissions made on behalf of the parties, this court finds no purpose would be subserved in keeping this writ petition pending. Stop. Secretary, West Bengal Board of Secondary Education, whether secretary is made party.
President is a party. I should give direction about president.
President.
President is a party.
Let president to take decision.
Lord.
President, West Bengal Board of Secondary Education, being respondent number 5. No. 3. Respondent 5. Respondent 3 is directed to decide in the prescribed application made by the headmaster of the school in the prescribed format dated 12 May 2022, seeking correction of date of birth of the petitioner by 6 weeks from the date of communication of this order.
Application is not made by the headmaster. Application is made by the petitioner.
But you are saying that it is made by
this application cannot be made by the headmaster, Your Lordship. Headmaster has to attest that it is going through the headmaster with the attestation of the headmaster. Can be submitted. Application made by the petitioner, not the headmaster.
Yes, I beg to apply for correction of my name.
Yes, Lordship.
It was not made by the headmaster.
Signature of the applicant. Yeah, signature of applicant.
আগেও একটা জায়গায় পড়া আছে হ্যাঁ ঠিক করে দিবেন হ্যাঁ এখানে দেখো তো বুঝলাম বলো সেন্টেন্সটা President, made by the petitioner and decide the application of the petitioner. Application of the petitioner.
In the prescribed format,
No, application of the petitioner. Decide application of the petitioner, which is at page 27 of the writ petition, by 6 weeks from the date of communication of this order. Stop. Before taking such decision, respondent number 3 shall be at liberty to hear the petitioner and the school authority where petitioner studied up to class 10 prior to participating in Madhyamik Pariksha 1984. Stop. Decision to be taken by the respondent number 3 shall be communicated to the petitioner by fortnight thereafter. Next paragraph, petition stands disposed of or then Xerox certificate copy.